Welcome. There are a few events in the life of the College of the Law that we look forward to each year, and this Constitution Day discussion hosted by the Rehnquist Center and with the support of the Federal Society and the Constitution Society are one of them, and I know you're in for a treat. With that, let me introduce my colleague, Associate Dean, Chief of Staff, and Director of the Rehnquist Center, Sally Ryder.
Thank you all for coming. As usual, we have a fantastic panel this year. We will discuss 4 cases. We'll have a break at 2:30, so I think there will be water outside and soda outside during the break. I'm going to give a brief introduction to our panelists, and then I'll turn it over to Professor Marcus. Really, Tony needs no introduction, but I'll do it anyways. Our former dean, Tony Massaro, who's a Regents professor here at the college. Tony's won the teaching award from the students so many times I don't think we can count all of them. She's a nationally known constitutional scholar, and she's a frequent participant in this program. Thank you, Tony. Next is Professor Andy Cohen, who just joined us this summer. We stole him or lured him away from Wisconsin, where he taught since 2008. He's also a well-known constitutional scholar who specializes on constitutional structures. Thank you for joining us, Andy. Oh, and I should add, he's also the Associate Director of the Rehnquist Center, so I'll clap for that. Next is Amy Howe. Amy is an editor and blogger on SCOTUS blog, which I think is the oldest, but certainly one of the most popular blogs about the Supreme Court. She practiced law in D.C. for many years and had an active Supreme Court practice before she decided to turn her energies to the SCOTUS blog full time. So thank you, Amy. Judge Neil Wake, who practiced law in Phoenix for about 30 years and was named to the bench by President Bush in 2004. Judge Wake is a real supporter of the college. He's not an alum, but I consider him an honorary alum because he does so much for us and participates in Constitution Day every year. And also I have a soft spot in my heart for Judge Wake because we grew up in the same neighborhood. So thank you. And finally, Professor Dave Marcus, who moderates this panel just about every year, does a fantastic job. Dave has in common with Professor Massaro, I think between the two of them, they've won the teaching award, I don't know, for the past 15 years or so, trade off and on. But Dave also won the teaching award when he visited at Yale 2 years ago. So you'll see his fantastic teaching skills in action when he sets the context for the discussion of the cases today and moderates this panel. So thank you, Professor Marcus.
We should all thank Sally Ryder and Bernadette Wilkinson also for putting together this wonderful event. It's a lot of work behind the scenes, and so we're most grateful for their efforts. As always, at Constitution Day, I feel like a kid at the grown-ups table. My job is to offer critical introductions of each of the 4 cases. I know nothing about constitutional law. I'm a simple civil procedure scholar, if I can dignify myself to suggest that I'm a scholar. So here's my advice. During my 10 minutes, if you have an iPad or a laptop, turn over to SCOTUS blog and read Ms. Howe's summaries of the cases. And when I'm done, you can then tune back in to the panelists. I'd like to take about 5 minutes to introduce this term before turning to Noel Canning, our first case. The legal scholars Eric Posner and Adrian Vermeule complain that we Americans suffer from a surfeit of tyrannophobia. Tyrannophobia is the unwarranted fear that tyranny lurks around every corner, that every unilateral action by the president or every federal statute ostensibly taking power from the states is a step closer to dictatorship. Professors Posner and Vermeule quite rightly argue that there are powerful constraints in American society and politics that will forever prevent the president from assuming anywhere near dictatorial powers. But 238 years of limited government notwithstanding, we always manage to convince ourselves that we're always on the verge of a tyrannical central government. Tyrannophobia is not just benign paranoia, it's destructive. It precludes certain reforms that would enable our federal government to act more effectively in response to problems of national and international scope. This fear of the exercise of centralized power is a problem because we live in a centralized world. Surely the diffusion of power to the states, to individuals, is a bulwark against tyranny, but there's always the danger of too much diffusion, an excess that tyrannophobia urges. This is particularly so given that problems that our country faces are often of a scale not commensurate with our federalist system of government. I believe that several justices suffer from tyrannophobia. In recent years, the Supreme Court has come pretty close to making some remarkably destabilizing decisions, ostensibly in the name of liberty and protecting against tyranny. The Court came close to do so in its Affordable Care Act decision of a couple years ago, and it has come close to doing so in a couple of important recent decisions on the regulatory power of the federal government. This past term, the Court did not really have occasion to rethink how American government should work. The cases we'll discuss today are, on the scale of things, mostly small potatoes, compared to some of the blockbuster decisions that the Court has rendered in recent years. I would characterize the past term as a mostly quiet one. But still, a recurring feature of some of the Court's decisions is this tyrannophobia. Some of the opinions are chock full of fantastic claims of liberty lost and the power expanded should the Court rule this way or that. Now, maybe the justices are simply fighting over Justice Kennedy's vote, a famous libertarian. Justice Kennedy, of course, the swing justice. And perhaps the other justices think that the more liberty they can throw at him, the more likely it is that he'll join them. But I think it's more than this. I think that some of the justices genuinely believe that tyranny is all but upon us. These justices signal this tyrannophobia in a couple of ways. Sure, most obviously, they do so with their rhetoric. But they also do so with a method of constitutional interpretation. An originalism that treats the founding generation as a group of angels, the Federalist Papers as a blueprint to everything good and right, and everything that has happened since the New Deal as a turn toward fascism. This tyrannophobia didn't actually do all that much this term. As mentioned, I think it was a quiet one. The justices had little opportunity to remake any structures of American government. But the irrational fear is lurking, and I believe it is worrying. The Court is obviously more concerned with phantoms of lost liberty than it is with the reality of dysfunction in modern American government. What will this tyrannophobia do when the Court has before it a case implicating a central pillar of the modern regulatory state? Okay, with those dire words, I'd like to turn to the first case, Noel Canning, and I think it's the case that perhaps best illustrates what I've talked about thus far. Okay, I think by my accounting I have 10 more minutes. As a matter of constitutional doctrine, the Noel Canning case is about the power of the President to make appointments without the advice or consent of the Senate while the Senate is in recess. The opinions in this case also perfectly juxtapose theories of constitutional interpretation, and for that reason might be read more for their methodological significance than their doctrinal importance. What I think Noel Canning does best, though, is to illustrate the absurdity of this tyrannophobia in modern American constitutional discourse. Noel Canning was the rarest of cases for the Supreme Court, its very first opportunity to interpret a particular constitutional text. The United States Constitution provides two ways by which the President can appoint officers of the United States. Article 2, Section 2 provides that the President can do so with the advice and consent of the Senate. But it also provides that the President can, and here I quote verbatim, fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. This language authorizes the President to make so-called recess appointments to the federal bench, to ambassadorships, to executive agencies, to head cabinet positions and the like. The framers gave this power to the President because in the 1790s, travel difficulties meant that the Senate met only once a year for a couple of months. If a vitally important post became vacant during one of these lengthy recesses between Senate sessions, the President would not have to wait until the Senate reconvened many months later to fill it. Over the last 100 years, however, the Recess Appointments Clause has taken on a new, more politicized meaning. To understand what I mean, I have to talk a little bit about the nitty-gritty of congressional procedure. Congress can take two types of recesses. The first are called intersession recesses. Intersession recesses are between two sessions of Congress. Typically, a session starts on January 3rd, and then it ends sometime in the fall when the Congress adjourns sine die, or that is, without a fixed day for reconvening. The day is then fixed by law. The second type of recess is called an intra-session recess. These are brief breaks that Congress takes, usually over holidays, to allow members to fly home, to meet with constituents, and so forth. As travel grew more efficient toward the end of the 19th century, the Senate began to have shorter intersession recesses and more frequent intra-session recesses. Presidents took advantage. So let's say that you're George W. Bush having a nice Memorial Day weekend in 2004. You've nominated a man named Adam Lindman to the Advisory Board for Cuba Broadcasting, a position that I'm sure you all know requires Senate confirmation. Also, as everyone knows, there is no political issue more divisive in this country than who gets to serve on the Advisory Board for Cuba Broadcasting. The Senate refuses to confirm Mr. Lindman, concerned, for instance, about the 15-foot pink phallus he has erected on his Long Island estate. This hypothetical, by the way, is based on reality. So you're George Bush, you're munching on a pretzel in the White House circa May 2004, and you don't know what to do. So you have an idea. You'll wait until the Senate recesses for Memorial Day, then appoint Mr. Lindman to this vitally important board as a recess appointee bypassing the Senate. In fact, President Bush made 12 such recess appointments over Memorial Day weekend 2004. Now, why does all of this matter? Recess appointments have included people more consequential to the American Republic than Adam Lindman, including, for example, Alan Greenspan. On one hand, the overuse of recess appointments undermines the balance of powers the ordinary appointments clause strikes by requiring senatorial advice and consent. The president can assume for himself tyrannical powers to appoint cronies and yes-men to the federal bureaucracy. On the other hand, senatorial intransigence over personnel can cause gridlock. Just think about the judicial vacancies in the District of Arizona, a problem that for several years saddled our district judges with the highest caseload in the country. The question at issue in Noel Canning is whether intra-session recess appointments are constitutional. The facts of the case have to do with President Obama's attempt to make several executive branch appointments. Now, forget about the NLRB, one of the litigants here. I'd like to focus on a man named Richard Cordray. Richard Cordray was nominated to head the Consumer Financial Protection Bureau, an agency created by statute by Congress in 2010 when both houses were under Democratic control. The Republicans hate the CFPB. They can't enact legislation to weaken it or get rid of it because it wouldn't get through the Democratic Senate and wouldn't get past President Obama's signature. So the solution that they came up with was to refuse to confirm any director to the CFPB until President Obama agreed to weaken the Bureau. The Republican senators, however, are in the minority in the Senate. If there were an up or down vote on Cordray's nomination, he would sail through. So they filibustered his appointment for 6 months, starting in July of 2001. But a holiday recess was looming in December, and with it the possibility of a recess appointment. What would the Republican senators do? Well, they had an ingenious idea. Senator David Vitter of Louisiana asked his House colleagues, and the House Republican colleagues, to engage in a little bit of a trick. The adjournment clause of Article 1 of the U.S. Constitution prohibits a House of Congress from adjourning for more than 3 days without consent from the other House. So David Vitter invited his colleagues in the House to refuse to give consent to the Senate to adjourn. Now, the House has no formal role in the appointment or confirmation of presidential appointees. But what the House's refusal to give consent to adjourn meant was that during the 6 weeks or so that the senators were at home for Christmas and the other holidays and not intending to do any legislative work, a senator had to show up every 3 days, gavel the Senate into session, mutter something senatorial, gavel the Senate to a close, so that there would be these perfunctory sessions to ensure that the Senate remained within the limits of the adjournment clause. The House Republicans and David Vitter thought that no president would have the temerity to call a 3-day gap between these perfunctory sessions a recess and use the recess appointments power to fill the CFPB position. But President Obama, our great tyrant-in-chief, did just this. So the question before the court is the following. Are intra-session recess appointments like Cordray's constitutional? Here's the relevant text. The president can fill up all vacancies that may happen during the recess of the Senate. This text produced 3 relevant questions. Question number 1, does the term the recess refer only to intersession recesses, or does it include intra-session recesses as well? Question number 2, does the phrase all vacancies that may happen during the recess refer only to vacancies that come into existence during the recess, or does it include vacancies that arise prior to the recess but continue into the recess as well? And then question number 3, how long does a pause in Senate business have to be to count as a recess? The last time I encountered questions of such absurdity was when I was at a meeting of my son's soccer league, learning about the rules for this, so that parents don't, cause emotional trauma for the little kids. The Supreme Court justices were unanimous in their holding that Obama had not lawfully appointed Richard Cordray. But the surface unanimity over the result masked a deep and bitter divide over the, mostly having to do with the proper method of constitutional interpretation. Justice Breyer, writing for the liberal justices, and Justice Kennedy used what the great legal scholar Cass Sunstein calls a Burkean approach to constitutional interpretation. Breyer bent over backward to find ambiguity in the relevant constitutional text for questions 1 and 2. Yes, the clause refers to the recess, using a definite article to suggest that a session of Congress can only have one recess. Logically, this must be the intersession recess, but our founders used definite articles in different ways, and surely the fate of the Republic should not turn on the difference between the and a. Yes, vacancies must happen during a recess, and this language would seem to limit the president's power to appoint only someone who leaves office during a Senate recess. But Republic-era dictionaries are equivocal on what to happen really meant at the time. Given this textual ambiguity, Justice Breyer reasoned the best thing to do is to look to history to see how recess appointments have been made and understood over time. And it turns out that for about 100 years, presidents have made these intra-session appointments. But Breyer reasoned a three-day break is too short for such appointments. Thus, the president can make intra-session recess appointments, just not during breaks as short as the one that Obama used for the Cordray appointment. Breyer's reading of the and happen almost caused Justice Scalia's aorta to rupture. Article 2 refers to the session, and surely by juxtaposing the recess against the session, the authors intended the recess to refer to the single intersession recess. But will our courts look willfully the other way and pretend that the disaster of modern congressional government isn't what it really is, and let the republics be damned because of what the and happen meant in 1787? Constitutional interpretation is not a suicide pact, Breyer's opinion all but says, and we're not going to sacrifice a functional modern American government on the arch purity of originalism. Scalia's opinion begins with all sorts of dire warnings about lost liberty if we empower the president, as Justice Breyer's opinion seems to do, and weaken the control of the Senate over appointments. But this tyrannophobia is ridiculous. There's an implicit rebuke to Justice Scalia's fear-mongering in Breyer's Burkean approach to constitutional interpretation. If the Republic has survived 100 years of intra-session recess appointments, we'll probably be okay. To my mind, there's a deep underlying conflict about the meaning of our constitutional structure in Noel Canning. Constitutional structure, the separation of powers, federalism, these may be about the preservation of liberty, but they're also about a functional government. What happened leading up to Noel Canning was a perversion of that structure to thwart functional government. A Senate minority used a filibuster, a voting rule that appears nowhere in the Constitution, to accomplish what it could not accomplish by majority vote, that is, the reform of the CFPB. When that strategy was about to fail, a Senate minority enlisted help from the House, a body to which the Constitution gives no power over appointments at all, to keep the filibuster's effect going. To reward these shenanigans, as Justice Scalia's originalism would have done, would have privileged some fantastic fear of lost liberty as a constitutional concern over the very unfortunate realities of government dysfunction. Justice Breyer's opinion, to my mind, quite rightly, makes the functional workaday realities of modern government a valid input for constitutional interpretation. Okay, I'm going to stop and turn this over to Judge Wake. Or, I'm sorry, are we starting with?
I guess they passed it to me. Well, this is a case about the structure of constitutional institutions. That's actually a rare case. I have been marveling lately at the fact that a document written 225 years ago is still in operation. It's written for a country of a population of 3 million people, sparsely spread across the eastern coast, and now it operates across the continent, halfway across the Pacific Ocean, and within eyesight of Russia. This is amazing. I've thought, and I've heard others say, and it strikes me as right, that one of the reasons the Constitution is still working is because there's so little there. It doesn't really do a whole lot. It sets some very general institutions, and there has, in fact, and there's some fine details as well. But most of what really defines the operation of a government or society, the Constitution in a smaller sense, with a small c instead of a capital C, it really isn't there and has been created and changed over time. So if we think about the really important things about how our government works, some of the things are they weren't contemplated or in the text. The Commerce Clause has been expanded to create a broad national power. The rise of political parties created a way for political activity across state lines that was not contemplated. Active judicial review, where the courts actually tell the executive branch and order them to implement the court's view of the Constitution, that's only barely 100 years old. The defensive view of judicial review in Marbury versus Madison was really limited to the court's activity in the judicial function itself. We have this massive delegation of legislative power and broad discretion to agencies, freeing Congress from the pervasive details of legislating, and some would say freeing them from accountability for it. And we have voluminous congressional legislation created by staff, not read by any senator or congressman, that's only understood in its major purposes, the talking points. Really none of that's in the Constitution. It has grown up, perhaps of necessity, perhaps for convenience, and yet it's operating under this amazing text of barely more than 200 years old. Well, this case is one of those structural cases about appointment powers between the President and the Senate under the Recess Clause. And as David said, the issues are, one, does this only apply to intersession recesses or also intrasession recesses now? Now, I have, in high school and college, 7 years of credit of studying Latin, and I can't remember the difference between those two. Why don't we just say between session recesses and within session recesses? But that's another subject. Second question is, does it apply to vacancies only arising during the recess, or to vacancies that arose before the recess? And third is how long? Well, I will give you my statement of the holding here, and it is that the President's recess appointment power exists for any 10-day recess, or shorter if you have a really good reason that we can't think of happening in the real world. Now, those are not the words they used, but I submit that it's an empirically accurate restatement. Professor Massar, you can tell me whether that would work for a law school exam. But now this case is really about methodologies. The majority's approach, it says the language, the standalone language is ambiguous. That opens up for interpretation. History is mixed. There's history on both sides, but the majority concludes the history tends to favor executive flexibility. The original intent of the framers cannot be dispositive here, because they would not have thought about any of these problems in a day when Congress met once for a short period of time every 2 years. They wouldn't have thought about within session recesses. So they fall back then on the broader purposes of executive branch continuity, with this respect for the Senate's check on appointments, and they favor the resolution they've come to. And the dissenting justices, Justice Scalia, say that the language is clear. It just means intercession, between session vacancies. That's what the recess means, end of discussion. And the history of executive conduct is just an executive usurpation, so it doesn't really answer the question. And by the way, the Senate's never really in recess anymore, so we can sort of forget about the Recess Appointments Clause. The paramount consideration here should be the Democratic check, the Senate check on executive power. That's the two competing analyses. And I do want to say, I think part of this, the dissenters they're basically right. The history of conduct here, whether you call it an executive act usurpation or correct applications, doesn't mean much when the Senate is not institutionally able to stand and say, that's wrong. The Senate acts by gathering a majority to enact something. The Senate doesn't act by majorities objecting to something the President has done unless it's something that can pass through a bill. So I think there is some legitimacy to that criticism. I'll offer my brief assessment, and it applies to some of the other things we'll discuss today. Language cannot be clear if the question could not have been within the contemplation of the speaker. Language serves an intended meaning. Words are not predestination for an unknown future. So, and the original intent cannot mean only what the framers thought about. Often in the law doesn't contemplate specific outcomes. It contemplates processes and values to be promoted. And now sometimes there are matters where original intent, just like legislation that's clear and specific, controls. But there's a lot of constitutional provisions as well as legislation that really directs the judiciary to decide future cases in light of those objectives. So I submit the issue here of original intent. It can decide some questions, but here it really is a delusion to think that it would decide this case. I suppose my bottom line assessment is what the court here did is it's a pretty decent accommodation. It's generous to the executive branch and to the appointment power, but it has the justification in that it assumes, and fairly so, that the Senate will treat appointments with the gravity and the urgency that they deserve, and if not, the executive branch continues operating.
This was actually my favorite, not only my favorite case of the term, but my favorite case of several terms, for two reasons, one of which is totally self-absorbed, which is that back in 2004, when the second President Bush was making recess appointments, I spent a good deal of time challenging, on a team that was challenging one of those, the appointment of Judge William Pryor to the 11th Circuit. And so we had made all, and so we were sort of vindicated in the sense that the court did eventually rule that the recess appointments were unconstitutional. But my favorite argument, I have to admit, was always the happen argument. And so there was one day I was on the phone with my brother, who is a Republican lobbyist in Alabama, from which Judge Pryor hails, and my brother was completely mortified that I was involved in this litigation. And if I'm going to be involved in this litigation, I should at least have had the decency to change my last name when I got married. But so I'm on the phone with him, and I said, no, really, listen to the text of the Constitution, and it says the vacancies and vacancies which may happen. And there's this pause, and you have to picture this with my brother, who has a thick Southern accent now that he lives in Alabama, and he says, so let me get this straight. You and Ted Kennedy are now strict constructionists? And I said, yes, we are. So we threw a whole bunch of cases at the Supreme Court. It was like Goldilocks and the Three Bears, trying to get the procedural posture just right. And the court looked at all of them, and it held on to some of them for a while. And then after a conference one day, I think it was January 2005, we got an order that cert had been denied. There were no dissents from the denial of certiorari. Justice Stevens, God bless him, did write a statement respecting the denial of certiorari, in which he said, in essence, and I'm paraphrasing here, this is a power that has not been used that often, and we trust that it will not be used often in the future. So I think it was sort of a warning shot, and after that, the Bush administration did slow down on the recess appointments, but then the Obama administration ran into its own set of difficulties making appointments, and the recess appointments resumed. And so, I tell this story not just to illustrate why I like the case, but also because it really illustrates that the issue, at least going into the Supreme Court, was non-ideological, in the sense that the people who didn't like the recess appointments were the people who weren't making the recess appointments were the people who didn't like the recess appointees. So you had challenges in the Bush administration and now the challenges in the Obama administration. So in theory it's non-ideological, and then as Dave and Judge Wake have described, this just sort of epic display of a clash of visions of the Constitution. We've got the text, we've got the history, and how are we going to decide this? I have to say that despite my incredible affinity for the happen argument, I think that for the most part, the majority probably, and I say majority in the sense of Justice Breyer's opinion for the court. I mean, one of the things that's interesting, there was a lot of talk right around this time of year, in June, right around this the time that this decision was issued in June, about what journalists like to call phononymity. The idea that the Supreme Court was issuing these decisions and it looked like they were all getting along really well. They all agreed that the Obama administration had overstepped here, but there were really fundamental differences in the rationales that they used to get there. And so this was actually the incredibly unusual case in which Justice Scalia took the step of reading his concurring opinion from the bench. I mean, it's a big deal, as you know, when a justice reads a dissenting opinion from the bench. So to take the time to read a concurring opinion at the end of June really gets people's notice. So it was non-ideological. We've got the clashing visions of the Constitution itself. A couple of bones to pick, I would say, though, with Justice Breyer's decision. And the first really is the idea is really predicated on the extent that the limits are not from the intercession versus intercession. The limits are not from the happen. The limits are this idea that the Senate gets to decide when it's in session and when it's not. In the days after the decision, there were blog posts that raised the idea that, that in fact the Senate, if as few as one senator shows up when they're having these pro forma sessions, and the Senate rules presume a quorum unless a single senator questions it. And so whether or not, if, as many people expect, after the election in November, the Republicans retake the majority in the Senate, they can hold these pro forma sessions. But, what if Mark Warner of Virginia shows up and says, I'd like to call for a quorum, there's nobody there, and the pro forma session is essentially negated. And I think that there's sort of an incredible gray area right now. I mean, I think that the limits on the president from Justice Breyer's opinion come from this idea, and I'm not sure, and if someone can correct me, I'd be glad to hear it, that maybe a single senator can actually thwart the Senate saying when it's in session. My other sort of bone to pick with the majority opinion is how they arrived at the number 10 in terms of the number of days of a recess. I think Justice Breyer said that for the most part, no recess appointments have been made during recesses that have been shorter than 10 days. And certainly there were some that were made during recesses that were longer, but somehow this idea that 10 is a magic number. And so there was a decision by the 10th Circuit, of all places, not that long ago, ruling on another recess appointments challenge to another member of the NLRB, and it said, well, clearly he was appointed during a recess that was 14 days long. So obviously this passes constitutional muster. And where would the founders have drawn the line between 10 and 14 days is a little bit of a gray area to me. And finally, just sort of again talking about the divergent views of the Constitution, and I will stop in just a moment. Just as it's not only in terms of the role of history and practice, but Justice Scalia's idea that the idea that the executive and Congress have worked out this compromise over the years is in his view not necessarily a reason to uphold the recess appointment practice generally. In his view, the idea is that separation of powers actually exists for the protection of the individuals, and that the two branches of government cannot sort of collude to rewrite the Constitution. His words, not mine. Thank you.
I think we got started about 10 minutes late, so we're going to just go 10 minutes longer, if that's okay, and then we'll make up the time. Somehow, magically, Sally will help us make up the time.
So I want to respectfully push back on what I think is one of the common themes of each of the commentaries so far, including Dave's summary to get us started here, and that is that this case is principally about a clash between competing visions of constitutional interpretation. There is a lot of originalism and a lot of analysis of the constitutional text and its meaning in the founding era in Justice Breyer's opinion for the majority. And there is a lot of history in Justice Scalia's concurring opinion, which really dissents from the principal legal conclusions reached by the majority. Justice Scalia's opinion also begins with the kind of offhanded acknowledgement that, sure, if you just look at the plain meaning of the constitutional text in this context, it is in fact ambiguous in the way that the majority claims that it is ambiguous. And so I really think this is a case that is more about the concurring justices' Tariff Phobia, as Dave dubbed it, quoting Professors Vermeule and Posner in his opening remarks. And that, in combination with a fundamental disagreement about the institutional competence of the court to address questions of separations of power over which the political branches of the government have disagreed. All right. Okay. Thank you. Is this all right here? My apologies. So let's talk about Tariff Phobia first. The Recess Appointments Clause clearly attempts to strike a balance between two competing purposes. The first of those purposes is a desire to give the president the power he needs to staff the executive branch to keep the government running when Congress is unavailable to serve its advise and consent function. The second of those purposes is to cabin the ability of the president to go around Congress in making such appointments, to limit his ability to make such appointments, to ensure that the Recess Appointments Clause exception doesn't swallow the advise and consent requirement rule. The two opinions in the Noel Canning case, it seems to me, each grab onto one of those purposes and completely ignore the other. So the majority focuses entirely on the purpose behind the Recess Appointment Clause to keep the government running, to empower the president to make the appointments he needs to continue to staff the government when the Senate is unavailable to approve his appointments. And the dissent focuses almost entirely on the clause's desire to closely circumscribe the president's recess appointment power to ensure that the Senate maintains a primary role in screening, in vetting, and ultimately approving the president's appointments to important executive branch positions. The appeal, it seems to me, and the sort of monomaniacal focus on the second purpose by the dissent is, I think this is apparent from the rhetoric of the dissenting opinion, some of which Dave emphasized in his opening remarks, is a concern that authorizing the president, adopting a reading of the Recess Appointments Clause, which permits the president to engage in opportunistic behavior, permits the president to time his appointments in ways that enable him to go around a recalcitrant Senate, threatens to eliminate, to free the president of any limits on that authority. This is a very pragmatic concern. This is a concern that is driven by an understanding of the purpose of the Recess Appointments Clause. This is not a concern that it's possible to deduce purely from an analysis of the original text or purely even from an analysis of the historical practice. The majority opinion is like a mirror image of the dissenting opinion. It focuses almost exclusively on the desirability, the need to preserve a working and an efficient government. It emphasizes different aspects of the founding era history. It emphasizes Hamilton over Madison in particular, quoting one of Hamilton's statements in the Federalist Papers, emphasizing that the liberty of the people requires vigorous and efficient government. And ultimately, I think there is a fundamental ideological divide between the majority and the dissent about which of these purposes is more important. But it's also really important not to forget that the majority here ultimately comes down against the president. And the majority here ultimately endorses an important check on the president's authority. The majority ultimately says in the final portion of its opinion that basically the Senate gets the final say on whether the Senate is in recess or not, a holding which, at least based on the court's understanding of Senate procedure, gives the Senate a very powerful tool to block these presidential abuse of the recess appointments power, maybe even too powerful a tool, maybe even a tool that enables a few minority party senators in collusion with members of the House to block the president's appointments when a majority of senators would not agree to do so. Now, it's possible, as Amy suggested, that this holding is premised on a misunderstanding of the finer points of Senate procedure, but I think ultimately the motivating impetus behind it is an anxiety, a hesitation, a trepidation on the part of the majority justices about intervening in this interbranch conflict on a question where the Constitution provides very little guidance about the appropriate balance of the two purposes, the appropriate balances to be struck between the two purposes of preserving efficient government and ensuring that the Senate has an important role in deciding who gets appointed to the executive branch. And ultimately, I think the majority's sort of half a loaf decision in this case is a product of its desire not to make that decision for itself, but to ensure that the Senate has the tools it needs to defend itself in the kind of interbranch warfare that often decides these separation of powers questions. Tony?
What do you think?
I made a deal on the side. I have a lot, but there's nobody I'd rather hear from than our own Chief Justice, and so I've given him the chance to weigh in at this point if you wanted to, and you don't have to if you don't want to. And then I'll fill up the remaining time when the red light goes on.
I'm flattered at the offer. I'll make 3 short observations and then eager to listen to your remarks. One thing that is notable that I think is going on is actually a debate between Justice Scalia and Justice Kennedy about how history should or shouldn't enter into the analysis of these kind of issues. If you read Scalia's dissent, and you look at the cases he cited and the cases he's quoted, he's bam, throwing back in Justice Kennedy's face things that Justice Kennedy has said. For example, Scalia says it doesn't matter that this might upset a whole lot of laws if that's what the text of the Constitution requires. After all, look at INS versus Chara. Well, Justice Kennedy, while still in the Ninth Circuit, had written INS versus Chara, and his analysis of that issue was consistent with what the Supreme Court ultimately said. So I think Justice Kennedy was the swing vote in this case, and what's in the majority opinion partly reflects the back and forth between Scalia and Justice Kennedy, something that was reflected earlier in Dean versus Bush, in Justice Kennedy's opinion and Justice Kennedy's. Second thing, it's interesting how the purpose that's attributed to the recess appointment clause can be expressed at different levels of generality. Professor Cohen talked about efficiency in government, and that's certainly a well-supported perspective, but you may ask, is it efficiency in government in the 18th century sense when Congress disappeared over the summer because everyone was going back to their farms and that quickly, or should it be efficiency in government in terms of the modern reality of intensely partisan politics, which the framers have never envisioned in political party systems? And then I guess my last comment is something that links there about how our Constitution may have endured because it says relatively little. And there have been scholars who say that the genius of the framers was they knew how to say enough but not too much. And given the way our political processes have evolved, can we continue to afford the luxury of a constitution that is, at least as compared to others around the world, very terse, particularly in terms of how it doesn't talk at all about the way political parties operate under our system of government?
Well, I want to push back on the tyrannophobia being the meta explanation for what's going on in the court right now. I think that a little bit of the math is helpful. Kennedy, 94%, he's in the majority, and in every single 5-4 opinion, Kennedy's in the 5. And 65%, everyone was, this is what Ms. Howe referred to, everyone was all, isn't this terrific, or isn't this deplorable? 65% of the opinions were unanimous. And this is maybe moving the court in the direction that was promised by Chief Justice Roberts, that we're going to achieve more unanimity, and that's a good thing. I say to this last poppycock, as many people have said, these were unanimous only in the thinnest sense of the word. And I think it's not really about tyrannophobia, and I think we're going to prove that with U.S. against Bond. If we were really going to whip it up in order to argue that tyrannophobia explains a lot of what the court does, then, or even what a majority of the court does, what a case for doing it, where you have some statute that's going to apply to chemical carol, more on that in a second. Really almost absurd facts that would have been a perfect way for people on the news and the more sophisticated news to say, if the federal government can do this, my God, it can do anything, and talk about tyranny. And yet they pulled back from that in that case. Now, I think that what the court's flirting with is serious status concerns. That the court is and it's always an issue for the court, but I think that these faux unanimity, and small potatoes, as Dave calls it, cases, had to do with avoiding hard questions that would have made the divisions within the court look more stark. Particularly when you have 5-4 decisions, as we do now, where all 5 of the justices that tend to be in the majority from the conservative wing were appointed by Republican presidents. And the 4 who would be in the minority were appointed by Democratic presidents. And we have increasingly news reports and everything that doesn't just tell you what the case said, but tells you which president appointed the justice. And I think that it trivializes, perhaps some people may think properly so, but it reduces the court's stature in ways that I think is probably a matter for serious concern for this chief and for other members of the court. They've talked about it. There's nothing good about a court that's perceived by the American people as being nothing but legislators in robes. And this is not something about themselves that they want to believe to be true or want us to think is true. But that trope's out there, and I think it's next term it's going to be harder for them to avoid. I don't think there were small potatoes cases. In fact, I think that the cell phone case was a big potato case, and the ones for today, I think that the town of Greece is only deceptively small potatoes. I think it's potentially tectonic in terms of the ways in which this court, in that case, 5 conservative, and I'll say it, Catholic justices, white Catholic justices in 4 of them, and 1 African-American Catholic justice ruled in favor of a prayer that was explicitly sectarian at the town meeting. I don't think that's small potatoes at all. And I think that they have to cover their flank somewhat in some of these other cases when so many people are seeing them as political, as religious, as white male justices in some cases, or male justices more generally, evidencing tin-ear empathy for women, for civil rights, for racial and ethnic minorities, the voting rights cases and so on. And I think as the court settles in next week to the long conference, it's going to face gay rights and other issues that's going to make it really harder for it to duck on process and narrow statutory grounds. Moreover, I think it's poised to decide some cases where, unlike Brown versus Board, the likelihood that there's going to be an Earl Warren moment where they get a consensus on some sort of a shifting maneuver by the court is it's very unlikely. I don't see a unanimous decision coming down. So I think that, to me, going forward, it's less about tyrannophobia than robophobia. I think that they're a little worried about their credibility. And coming up against the president in the recess appointment case, I think both as a matter of law and as a matter of their own position, a lot of what I was going to say has been said. I'll just say as a matter of pure textualism, I think that Scalia's conclusion that the recess appointments clause is an anachronism, he says an historic relic whose original purpose has disappeared, I thought was really compelling. I thought he was right. I just thought it was beside the point of the Constitution and solving the problem of recess appointments in the modern era and for the reasons that the Chief Justice gave. I think many of us likely would agree with Justice Scalia when he says we're living in an era when the influence of the recess appointments is pernicious. It definitely can be, as Professor Cohen says, an end run around the Senate confirmation process. Nobody should want that. I mean, structurally. Or most people wouldn't want it structurally, right? But that can't be viewed in splendid isolation either. Let's be frank, and this comes from Dave's introduction. The pernicious conduct is also here by the Senate itself. We're living in an era in which invoking the recess appointment clause is necessary to prevent a kind of structural problem of just how far are they willing, is this dysfunctional Congress willing to go in distorting rules about when it's in session to engage in what many people have called nullification of the agencies themselves by any means necessary. So a pox on both their houses. I think it's why politics make me sick. It's hard not to find it all just kind of disgusting, right? And I think of Norm Ornstein, who was here not that long ago and has written a book that says it's even worse than you think. Enter the sensible, reasonable, I resonate to his opinions for this reason, voice of Justice Breyer. And he goes through it, and he says, point by point, and he resolves it in a way that's not satisfactory to everybody, but as Linda Greenhouse said in her recent column, it's already solved one case where he's come up with a line of sorts, and he's even with respect to the 10 days, he has wisely, I think, anticipated the bizarre possibility of situations we can't yet anticipate, in which it might be necessary to fill an appointment even if the recess is shorter still. And that's the kind of justice decision-making, I think, that will do better to preserve the long-range, over-time credibility of this court, that kind of pragmatic, starting with history but not ending there. And so I thought that Breyer did a terrific job in this case on an imperfect set of circumstances with two really important structural tensions at stake. And it might have been a time to give the president a loss, just as a matter of politics, because they'd given the president, at least in theory, a win with the Affordable Care Act the last go-round. Why did Kennedy land where he landed in this case? That's an offline, where's Kennedy? Why they pitched woo in this opinion to Roberts and to Kennedy. They couldn't stop quoting things, as you said, sir, as you said. And one of them was smitten and the other one wasn't. I think Roberts was smitten by the woo, and Kennedy shrugged and said, not this time. Because for Kennedy to have gone with the woo-woo, he would have had to have embraced a kind of static interpretation of the Constitution that would have caused him a heck of a lot more trouble down the line. I mean, I think that's the other side of him that was at stake there. He's just not a strict constructionist in that way, or he doesn't think that everything that happened in the 18th century when we ran around with tri-cornered hats was the most excellent time of all to be alive or to be thinking about the Constitution.
Okay, we started 10 minutes late, and we're now 20 minutes behind. So I'm going to take the moderator's prerogative to extend this session until 2:40, and so we'll have a slightly shorter break and try to make up a little bit of our time. So the next case we'll move on to, and I apologize we don't have time to discuss with everyone in the audience these cases. I'm hopeful we'll build that time in as we proceed. Okay, so the next case we'll talk about today, I'm just getting my stopwatch here, is Bond versus United States. Okay, so here's a joke. What do migratory birds and unfaithful husbands have in common? They've both flown the coop. I'm glad that Tony is laughing because she sent around so many insipid jokes about the Supreme Court and these decisions this summer as we were discussing these cases over email, that if she didn't laugh at that joke, I would have been absolutely infuriated. Bond versus United States emerged from the unlikely but salacious intersection of an unfaithful husband, a mentally deranged, vengeful spouse with an unusual gift for chemistry, and the International Convention on Chemical Weapons. But these facts are not sufficiently boring for Constitution Day, so let me start with migratory birds. Migratory birds were disappearing in the United States due to overhunting in the early 20th century. In 1913, Congress passed a statute aimed at protecting these migratory birds. But the problem was the statute was almost assuredly unconstitutional under the Commerce Clause jurisprudence then in effect. Congress has only those powers that Article 3 gives it. The power to regulate game was thought to be vested in the states. As the statute's authors fully expected, federal courts began to strike down the migratory bird statute as unconstitutional. So what were bird lovers of America to do? A senator with a manifest fondness for our feathered friends had a brilliant idea. Article 2, Section 2 of the United States Constitution contains the Treaty Clause. It provides the President shall have the power, by and with advice and consent of the Senate, to make treaties provided 2/3 of the senators present concur. Note, this language says nothing, has no express limits on the proper subject matter that treaties can cover. Moreover, Article 1, Section 8 contains the Necessary and Proper Clause. It provides, the Congress shall have power to make all laws which shall be necessary and proper for carrying into execution all powers vested by this Constitution in the government of the United States. Now here's the senator's idea. British people love birds. Let's enter into a treaty with Great Britain to protect them. There's nothing in the treaty clause that says that the United States can't do so. Then Congress can pass a law to implement the treaty domestically. That is a statute necessary to ensure that the United States meets its treaty obligations. Surely such a law would be constitutional under the Necessary and Proper Clause, even if Congress could not pass such a law without the treaty being on the books. Following the senator's lead, the United States did just this, doing by treaty and implementing legislation what Congress could not do directly, by legislation alone. Now surely the Supreme Court would not stand for such shenanigans. But in the 1920 Missouri versus Holland decision, the court upheld this elaborate end run around limits on Congress's power. If the treaty is valid, the court held, there can be no dispute about the validity of the statute under the Necessary and Proper Clause as a necessary and proper means to execute the powers of the government. In the 1920s, Missouri v. Holland caused a fair amount of heartburn about federal legislative tyranny, but then the anxiety subsided as Congress's power to legislate under Article 1 expanded under the New Deal Commerce Clause jurisprudence. When the court started reining in Congress's power in the 1990s, however, Missouri versus Holland started to loom large. Professors started playing around with a hypothetical that didn't seem all that far-fetched. Congress can't, by legislation, prohibit states from punishing certain crimes by death. But what if the President entered into a treaty with, say, Barbados, and the Senate ratified this treaty that prohibited the death penalty? Could Congress then, through implementing legislation, eradicate the death penalty domestically and in so doing evade Article 1 limits on its power? This is where poor Carol Ann Bond comes into play. Bond is a microbiologist living in Pennsylvania. In 2006, Bond discovered that her best friend was pregnant. This news came as quite welcome news until Bond then learned that her husband was the father of the baby. Carol Bond did not take the news very well. On 24 separate occasions, she snuck over to her friend's house and spread toxic chemicals on the friend's car door, mailbox, and doorknob. These chemicals were easy to see, however, and could be easily removed, and only once did the friend suffer a burn, a mild burn on her thumb, which she treated by washing with water. Eventually, surveillance cameras caught Bond stealing an envelope from the friend's mailbox and stuffing her car's muffler with a toxic chemical. Here's where another mentally deranged person enters the picture, the Assistant United States Attorney who prosecuted Bond. Rather than just charging Bond with mail theft or leaving Bond's fate up to a local DA and a potential assault charge, the U.S. Attorney charged her with a violation of the Chemical Weapons Convention Implementation Act. Congress passed this statute to implement the International Convention on Chemical Weapons, a treaty. The convention bans the use of chemical weapons. It requires member states to prohibit all persons from stockpiling or using chemical weapons, hence the federal statute passed to implement the Constitution. It forbids any person from using any chemical weapon. When you think about the Convention on Chemical Weapons and the Implementation Act, you should think about Syria, World War I, and the sarin gas attack on the Tokyo subway. The mentally deranged AUSA in Pennsylvania, however, thought about a jilted lover burning her rival's thumb. Bond was convicted of using a chemical weapon and sentenced to 6 years. Bond argued that the Implementation Act was unconstitutional. She noted that if Congress had enacted the ban on chemical weapons directly, the statute would have exceeded its enumerated powers. Bond insisted that Congress could not do an end run around this limit by getting a treaty ratified, then passing implementing legislation under the guise of the Necessary and Proper Clause. This is congressional tyranny. To put her argument directly, Congress's power to implement treaties does not exceed its power to enact legislation directly. This argument presented the court with a hugely consequential choice. If the United States accepted the argument, the decision could have significantly curtailed the United States' power to enter into treaties on human rights, education, labor, or other matters that in our domestic legal order are usually reserved to the states. This choice, however, will have to wait for another day. In a brilliant act of judicial minimalism, Chief Justice Roberts freed poor Ms. Bond from prison while avoiding the hard constitutional question. We don't need to decide whether the Implementation Act or the Chemical Weapons Treaty are lawful, the Chief argued. The Implementation Act, properly interpreted, did not apply to Bond. The Implementation Act threatened to arrogate to the federal government power that traditionally had been exercised by the states. When reading such statutes, the Chief insisted, what we might call a Federalism canon of statutory interpretation applies. Whenever possible, we will interpret these statutes to protect state power against federal aggrandizement. We will require a clear statement in the statute, the Chief continued, before we conclude that a statute reallocates power from the states to the federal government. The Implementation Act requires that Bond have knowingly used a chemical weapon. The Chief reasoned that the term chemical weapon is nowhere near clear enough to sweep within its ambit the ordinary household chemicals that Bond used to burn her rival's thumb. The ordinary and dictionary meanings of chemical weapon do not include the use of ordinary household chemicals to haplessly seek revenge for infidelity. The Chief summed up the absurdity of the government's reading of the statute in a wonderful passage. If Bond were thought to have used a chemical weapon in this instance, then any parent would be guilty of a serious federal offense, possession of a chemical weapon. When exasperated by the children's repeated failure to clean the goldfish tank, he considers poisoning the fish with a few drops of vinegar. I have to do a Constitution Day at my son's first grade class in a couple days, and I'm going to begin with that paragraph. I'm a very good father. Read with the clear statement rule required by the Federalism canon in mind, the Chief concluded, the Implementation Act simply cannot be interpreted to prohibit the sort of ordinary assault that Bond committed on her friend. The Chief's opinion sent Justice Scalia into a fit of apoplexy. To Scalia, the court should only apply the Federalism canon and require a clear statement when the statute is ambiguous. But the Implementation Act included a definition that defined chemical weapon, and the definition clearly swept within its ambit the chemicals that Bond used. The Chief Justice, Justice Scalia insisted, used the Federalism canon to create ambiguity where none existed. Justice Scalia wanted to reach the constitutional question. To him, the treaty power could not extend Congress's power beyond what Article I enumerated. To allow the treaty power to do so, he insisted, would upset the delicate arrangement of power in our constitutional order. Individual liberty would fall prey to a rapacious Congress bent on running all of our lives. This is tyrannophobia again. Now, I want to stress, I'm not suggesting that tyrannophobia is the operative element that's driving decision-making. I think that some of the justices suffer from it, and my concern is that in future years, this tyrannophobia will spread. Okay. In the end, the key issue in the case was not Missouri versus Holland and Congress's power to implement treaties. The conservative justices split instead on a very interesting question of proper methods of statutory interpretation. This question over interpretive methodology, however, is, while quite different from where we began, the treaty power and the necessary and proper clause, is nonetheless quite related to the constitutional question. It has long been argued that what protects the power of the states from a federal government bent on usurping the state power and ultimately individual liberty are what are called the political safeguards of federalism. Congress is set up in a way to protect, not erode, state sovereignty. Given the natural inclinations of senators and the like to protect states' interests, a court does not need to worry so much about protecting states by interpreting congressional power narrowly. Libertarians got interested in the Bond case because Missouri versus Holland is anathema to them. It seems to give Congress an end run around strict limits on Article I, on federal power under Article I. But if there were ever an instance where the political safeguards of federalism work, it is in the treaty context. Yes, it is hypothetically possible that under Missouri versus Holland, the United States could enter into a treaty with Barbados and agree to prohibit the death penalty. But this treaty would require 2/3 of senators to vote for it, the president's signature, and then majorities in both houses of Congress to vote for the implementing legislation. There is absolutely no chance that the Barbados death penalty treaty would survive this gauntlet. There's a very good practical reason why Missouri versus Holland has never really amounted to very much. The political safeguards work quite well here. The Chief Justice steered a brilliant path around the treaty power issue in bond, and I earnestly hope that the bond issue remains safely tucked away in the nation's law reviews where it belongs along with other hyperbolic, tyrannophobic worries. Okay, Andy.
So, thanks, Dave. That was a really entertaining opening to this discussion, and I'm sure that mine will not be nearly as funny. I'll try to make it just half as informative, and if I do, I think I'll have succeeded. So I want to highlight just what I think are three really interesting, maybe four if I have time, really interesting aspects of this case. The first is the canon of statutory interpretation that Chief Justice Roberts invokes to limit the Chemical Weapons Convention Implementation Act, which is a subtle variation on a clear statement rule that the court has long employed to disfavor exercises of federal power that intrude upon traditional areas of state concern. And it's really this subtle variation, this subtle expansion of the Federalism clear statement rule, which ultimately drives the majority's disagreement with the dissent, at least at a doctrinal level. And the new twist that Chief Justice Roberts adds to the old rule, which is that any ambiguous statute should be interpreted to avoid a understanding or implying a view of federal power that encroaches on traditional areas of state concern, is to suggest that the fact that a statute, in this case the Chemical Weapons Convention Implementation Act, the very fact that an act seems to intrude on traditional areas of state concern can itself be a reason for reading that statute as ambiguous or finding that statute ambiguous because, as a general rule, Congress, it is assumed or presumed, possibly fictionally, but in any case, it is presumed that Congress would not, without exceptionally clear language, venture into this sort of constitutional netherworld. And this, I think, represents a meaningful, substantial, and potentially consequential expansion on this Federalism clear statement rule, which the court has been applying with some frequency since at least Gregory versus Ashcroft in 1991. The disagreement here with Justice Scalia is in the majority's attempt to use the federalism issue as part of its analysis of whether the statute is ambiguous in the first instance. Justice Scalia argues in dissent on the way to concluding that he must reach the constitutional issue, which he clearly really wants to reach anyway, that the ambiguity analysis of a statute must rest entirely on its plain text, and only if a fair reading of the plain text of the statute is ambiguous should the court invoke the Federalism clear statement rule. So this all sounds fairly dry and technical. What is the upshot here? The upshot is that the new twist that Roberts invokes or imposes on the Federalism clear statement rule allows that rule to apply in a substantially broader range of cases. And not only does Chief Justice Roberts, broaden the Federalism clear statement rule in this important but subtle way, he gets all four liberal justices to sign on to this rule, making it more difficult for them to contest its broad application in future cases. And I'll have a little bit more to say about the politics of this if I have time. A couple of observations about the treaty power issue, which is only addressed by the dissent because, as Dave suggested, Chief Justice Roberts' resolution of this case allows him to decide that the Chemical Weapons Convention Implementation Act did not reach Ms. Bond's crime as a matter of statutory interpretation. But Justice Scalia was eager to reach the constitutional issue, as were Justices Alito and Thomas in this case. They read the statute, I think quite plausibly, in a way that required them to reach that issue. And I think their motivations for reaching that issue are twofold. One is the straightforward motivation which Dave mentioned, which is that they are afraid in the modern era of human rights treaties, treaties which deal not just with intercourse between foreign nations, but with the domestic obligations of a government towards its own citizens. They're worried about the United States entering into treaties, liberal human rights treaties, that will deprive states of the power to do things like impose the death penalty, bar same-sex marriage, or will enable Congress to do things like ban gender-motivated crimes of violence and provide civil remedies for gender-motivated crimes of violence, which it cannot do under its ordinary constitutional authority. So the three dissenting justices in this case, I guess, are these actually concurring justices? Again, concurring justices who actually dissent on the legal merits of the issues, addressed this concern in Justice Thomas's concurrence, in which they push the proposition that to the extent the Chemical Weapons Convention addresses the domestic obligations of the United States government, it's probably not even a treaty to begin with, because a treaty is, the term treaty, as it was originally understood, is limited to any agreement between the U.S. and a foreign government that governs the external intercourse of the parties to the treaty, rather than agreements which purport to impose domestic obligations on the U.S. government. But I think that the dissenters are also up to something else here, something which is closely related to their reading and also Chief Justice Roberts' reading of the Necessary and Proper Clause in the Affordable Care Act case. Justice Scalia's dissent, the principal dissent in this case, focuses not on the meaning of the President's power to make treaties, but on the meaning of Congress's power to make laws necessary and proper to carry those treaties into effect, and employs a variety of techniques, both of them drawn directly from, or at least the same techniques, which are employed to limit Congress's Necessary and Proper Clause in the Affordable Care Act case. And I think this is part of a larger, best understood as part of a larger effort on the part of at least some of the conservative justices to craft a jurisprudence of the Necessary and Proper Clause which enables the court to impose more stringent limits than the court has traditionally imposed under the dominant interpretation of McCulloch versus Maryland that presided basically up until at least the mid-1990s and probably presided up until at least the Affordable Care Act case a couple of years ago. I see that my time has expired, so I will turn things over to
Why don't we just go down straight down?
Okay. I've got a couple points, including from the perspective of sort of reporter and former practitioner. Andy covered the phononymity. I also think that this case is sort of a good lesson in the importance of a good lawyer. Dave didn't have time to get into the whole history of the case, but this was actually Mrs. Bond's second trip to the Supreme Court. She'd gone once on the question of whether or not she could challenge the constitutionality of her conviction at all, or whether or not a 10th Amendment challenge, which is what she was bringing, was something that only states were allowed to bring. And so somewhere along the line, after she was convicted, she pleaded guilty and reserved her right to appeal. She got herself a really good lawyer named Paul Clement, who I'm certain, like during the entire arc of this case, was thinking about the oral argument on the merits all along, and so was able to set this up in a really brilliant and spectacular and ultimately successful way. I guess the next point goes to the idea that this was incredible judicial minimalism. And I think it was. And I think that in this case, that was absolutely the right result. The court was divided, but, and I think that this is probably what at least 6 justices had in mind, that these are incredibly weighty issues dealing with the treaty power. And, they have to have been thinking, we really don't want to make this decision right now if we can help it. And we certainly don't want to be doing it in a case in which the chemicals that are alleged to be chemical weapons were purchased on Amazon.com. So I do think that this is, to follow up on your point, I think that this is an issue that probably will remain tucked away. I don't think that there are certainly 3 justices on the court we know who have an appetite to take up this question again, but I don't think that there is a 4th right now. And as most of you know, you need 4 justices to grant cert. So I think that this issue could go away for quite some time. Having said that, I want to flag, looking ahead, 2 cases in the upcoming term for which I think that the justices, well, I guess, and I had one other point that I wanted to make, sorry. As a journalist who covers the court, this was a really fun argument to watch. And sometimes there are points in the argument at which you get a really good sense all of a sudden based on 1 or 2 comments by the justices of how things are going to go. And so a couple of terms ago, there was a case called United States versus Jones, in which it involved whether or not the police could put a GPS tracker on a suspected drug dealer's car without a warrant and follow him around for 28 days. And there was a question from one of the justices, from Michael Dreeben, the really brilliant lawyer who argued on behalf of the government in that case. And one of the justices said, well, could you do this to my car? And under the government's rationale, Michael Dreeben had no choice but to say yes. And at that point, we could all start writing our stories, reflecting that Jones was going to win, and it was just a question of how. And so during the oral argument in this case, and if you haven't read the transcript or listened to it, I'd urge you to go back and do it. And Don Verrilli is trying very, very hard to get the justices to focus on things like Syria and how serious the implications of the court's decision could be. And Justice Alito has a question about whether or not, this is shortly after Halloween, he and his wife violated the chemical weapons ban by giving out chocolate to trick-or-treaters because the chemical weapons treaty, also the laws implementing, also apply to animals. And everyone knows that chocolate is toxic to dogs. And so at that point, I really felt like the question was not going to be whether or not Mrs. Bond was going to win, but was it going to be go big or go home? And it turned out they mostly went home. But I think that there are going to be echoes of Bond coming up in 2 cases, one involving overcriminalization. It's a case called Yates versus United States. And it's a case that involves a commercial fisherman in Florida who is being charged with violating the Sarbanes-Oxley anti-shredding provision because he is alleged to have destroyed 3 undersized grouper on his fishing boat when the Fish and Wildlife officers pulled him over. And so I think that just as the concerns about overcriminalization surfaced in Bond, I think they're going to surface again in Yates. Tony, you referred to robophobia in your last set of comments. And I think that in this case they did not have the appetite to take on the question. There's a case called Zivotofsky versus Kerry coming up that's set for argument either in November or December. There was 2002 law in which Congress directed that if you are a U.S. citizen born in Jerusalem and you want a passport, you can request that your passport say Israel instead of Jerusalem. The U.S. government's position for many decades has been that it is not going to put Israel on the passports of U.S. citizens born in Jerusalem because it does not want to be taking a side in the status of Jerusalem pending the outcome of the Middle East peace talks, whenever that may be. And so this is a decision that people in the U.S. are not necessarily paying a lot of attention to. Whatever the justices decide is going to have enormous implications overseas. If the justices issue a decision that says that if you are a U.S. citizen born in Jerusalem, your passport can say Israel, is not going to go down very well in most of the Middle East. And I think, on the one hand, the justices are going to be very conscious of that, but on the other hand, there were 4 justices who wanted to make this decision. This is another case that's actually on its second go-around at the Supreme Court. The last time it was whether or not this was a political question that courts could decide at all. The D.C. District and the D.C. Circuit said, yes, it's a political question. The Supreme Court said it is not a political question. Now go and decide the merits of the case. And so I've been assured by people who know more about this case than I do that there is no way out of this case. There's no alternative ground on which they can decide. And so this is something, this is not a mandatory jurisdiction case. This is something that they have decided to take on themselves and will be deciding by the end of June. So.
Judge, I'll cede my time so we get back on track.
I'll try to be short. This case is a play in which the main act never opens. That is, the constitutional limits on the treaty power. This becomes a one-act play after which it ends. But it's still a good show, a show about the methods of statutory interpretation, and specifically federal statutory interpretation. And for statutory interpretation, as I said earlier, plain language still requires the context of law and purposes, and the court emphasizes here that certain intrusions into strong principles of federalism require a clear statement, or it is assumed Congress meant its language to respect those principles. Legislation is always in the background of unexpressed assumptions, and I'm fond of quoting a passage from the late Professor Paul Bator, who said, no statute can restate the entire legal universe. That's what I think this case is about. And also, courts routinely construe general language of statutes so as to avoid harsh results unless there's clear indication that harsh results were intended. I see this as a routine example of judicial interpretation of statutes that take highly general words in light of context and limit the reach of those highly general words to expected conduct. And this is done because, first, that's how language works in general, because narrowing the language favors liberty, and because hostile readings of general language to make it overbroad and unconstitutional impairs the legislative function. Now, chemical weapons is at least ambiguous. If you draw upon a century of factual references for that phrase, the concurrences here take every turn to construe the statute harshly so as to declare it unconstitutional. Indeed, Justice Thomas's concurrence says, acknowledging this as dictum, he says, quote, in an appropriate case, I believe the court should address the scope of the treaty power as it was originally understood. He's talking there about the constitutional scope of the treaty power, not just the meaning of the statute that implements it. Remarkable, remarkable assertion of now I'm going to talk about dictum. And also the concurrence says, as is completely obvious, that they quote, Madison took the view that the treaty power was inherently limited. Well, if the treaty power is inherently limited so as to declare a treaty unconstitutional, why cannot legislation in a particular context be inherently limited in the same way? I submit all texts take meaning from context, and the concurrences invoke context and unstated assumptions to limit the treaty power, but deny it for interpreting the implementing statute itself. The court reached what to me is an unremarkable exercise of statutory interpretation to avoid very serious constitutional issues. And the concurrences fired their shot across the bow, so people are aware of it now, but this is a rather aggressive judicial undertaking of dictum.
Well, I'll end with a joke. Why not? So in the opinion, Justice Scalia says emphatically the statute parses itself. Sorry. In the opinion, I said I'll end with a joke and then we'll take a break. Scalia says the statute parses itself. And anybody who reads Anne Sexton poetry must think, boy, this is the beginning of a good one. And that probably describes maybe one of us in here. But I thought it was hilarious. Let's take a break and come back and for some more finger-licking bad cases.
So we will reconvene we're back on track, so we'll reconvene at 2:45. Okay, let's move on to our third case. I think this is Town of Greece. Is that right? I hope so. The issue in Town of Greece versus Galloway is easy to state. Can a town board begin its meetings with a prayer that is most often, but not necessarily Christian, without violating the Establishment Clause of the First Amendment? Here's how one scholar described the Establishment Clause landscape in 2006. At some point during the last 10 years, one or more of the 9 justices have articulated 10 different Establishment Clause standards. Many of the justices have endorsed several different and often conflicting constitutional standards. Justice O'Connor alone authored or signed opinions that relied on 5 different and again often contradictory standards for enforcing the Establishment Clause. It is absolutely criminal that I have to summarize this case, to situate it in doctrinal context. This is vastly overtaxes my capacity to engage in constitutional law thinking of any kind whatsoever, but I'll do my best. More seriously, Town of Greece lays the groundwork for an enfeebled Establishment Clause, one that abandons all but the thinnest of protections for people of minority faiths and forces them, or no faiths at all, and forces them to put their hopes, all of their hopes, in a reservoir of dubious depth, judicial empathy. No offense, Judge Wake. The Establishment Clause in the First Amendment reads as follows: Congress shall make no law respecting an establishment of religion. Other than Justice Thomas, most people agree that the Establishment Clause has been incorporated through the 14th Amendment to apply to the states. When a government allows a prayer at an official function, installs a nativity scene before Christmas, or otherwise seems to engage in or countenance religious activity, when does it run afoul of the Establishment Clause? For our purposes, that is, to provide doctrinal backdrop to the Town of Greece dispute, there are 2 ways to answer this question. The first is simple but crude. Up until 2014, any prayer at a government-sponsored event violated the Establishment Clause unless the prayer opened a legislative session. In Lee v. Weissman, the Supreme Court held that a clergy-led prayer at a school graduation ceremony violated the Establishment Clause. In Santa Fe Independent School District v. Doe, the Supreme Court held that a student-led prayer at a high school football game violated the Establishment Clause. However, in Marsh v. Chambers, the court rejected an Establishment Clause challenge to the Nebraska State Legislature's practice of opening its sessions with a prayer. The basis for the decision was little more than tradition. The first Congress opened with a prayer, legislatures have been opening with prayers ever since, and the Supreme Court wasn't going to change things. The second way to provide doctrinal background requires me to wade into the morass of Establishment Clause jurisprudence and try desperately not to drown. The old established and reviled test for an Establishment Clause violation comes from Lemon v. Kurtzman, a 1971 case. To survive an Establishment Clause challenge, a state action, number 1, must have a secular purpose, number 2, must have a principal or primary effect that neither advances nor hinders religion, and number 3, must not foster excessive entanglement between government and religion. The Lemon test isn't liked all that much. It's highly manipulable. It struck some as being particularly hostile to religion. The justices have been trying to change it ever since. Justice O'Connor pioneered a refinement of Lemon that is called the Endorsement Test. To quote the justice, the Establishment Clause prohibits government endorsement or disapproval of religion. Endorsement sends a message to non-adherents that they are outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders, favored members of the community. Note what the endorsement test does not require. It does not require that someone who doesn't like the government prayer feel compelled to participate in it. What it does recognize is that some people feel discomfort or take offense or unease. It's not that they feel coerced. They don't like being put in a position of having to respect the majoritarian faith. This is constitutionally problematic. This is a shortcoming. This lack of coercion is a shortcoming to other justices, notably Justice Kennedy, who prefers what is called the coercion test. The Establishment Clause prohibits the government from coercing anyone to support any religion. Coercion can be direct. A government could prohibit someone from attending any but the authorized church, or coercion can be indirect. The government cannot allow a situation wherein someone feels peer pressure to conform to the religious majority, like a school prayer. But note what the coercion test cares little about, this discomfort or offense that seems to me to be something significant for the endorsement test. Town of Greece, I believe, heralds the full-bore arrival of the coercion test, one that threatens to license all sorts of public piety. Greece is a small city of 94,000, bordering on Rochester in upstate New York. In 1999, the newly elected town supervisor began a practice of inviting local clergy to begin the monthly town board meetings with a prayer. The group of clergy who gave these prayers remind me of my high school class in Central Texas, not a lot of Jews. Between 1999 and 2007, only Christian clergy gave the opening prayer. When a lawsuit was about to be filed, the town invited a Jewish layman, not a rabbi, but doesn't matter, a Wiccan priest, and a Baha'i minister to begin the meetings. But after the lawsuit got going, they stopped doing that and just went back to the Christians. By the way, if you're bored right now, which I assume you are, ignore everything else and try to finish the following joke. A rabbi, a Wiccan priest, and a Baha'i minister walk into a bar. The person with the best joke, the prize for the best joke at the end of today's exercises, are a pair of front row tickets to the debut performance of Tony Massaro's first musical comedy, which he has entitled Town of Grease, Grease. Okay. I thought of that one late last night. Now, in fairness to the good people of Greece, yeah, it shows, ha, ha, ha. In fairness to the good people of Greece, there are almost no non-Christian houses of worship in the city. So there was no overt hostility to inviting non-Christian clergy to give the prayer. They just weren't in the phone book. Now, it would be one thing if these prayers were ecumenical, full of sort of non-sectarian words, but this wasn't the case. The prayers were quite Christian, full of mentions of Jesus, the Holy Trinity, Son of God, and so forth. Applying something like the endorsement test, the Second Circuit held that the town's practice violated the Establishment Clause. The practice gave off the sense that the town had affiliated itself with Christianity. But in a 5-4 decision, the Supreme Court reversed. The town's prayer practices didn't violate the Establishment Clause. Justice Kennedy, a Catholic, wrote for himself and 4 other Catholic justices. Justice Kagan, a Jew, wrote for herself, 2 other Jews, and a Catholic. The plaintiffs did not challenge the practice of beginning each meeting with a prayer. Rather, they challenged the sectarian nature of the prayers. What they wanted was an order requiring the prayers to be non-denominational. But Justice Kennedy would have none of this. To my mind, his opinion makes 3 key moves. First, Kennedy aligned the practice of beginning town board meetings with prayer with beginning legislative sessions with prayer, what the court approved of in Marsh versus Chambers. Now, to my mind, this is nonsense. There's a world of difference that separates the beginning of a legislative session where nobody is watching, there's almost no one in the chamber, from a town board meeting with applicants for zoning variances and kids with prize-winning school essays in the audience. But Kennedy's move was important because once he aligned the board meeting prayer with a legislative session prayer, he placed a heavy burden on the plaintiffs to establish their constitutional injury, and this they could not do. Okay. As a second move, Kennedy explained that an insistence on non-sectarian prayer would be inconsistent with a history of Christian prayer in legislatures, and it would involve the government in the censorship of prayers. Doing so is a non-starter, Kennedy insisted. Government may not mandate a civic religion that stifles any but the most generic reference to the sacred any more than it may prescribe a religious orthodoxy. Once it invites prayer into the public sphere, he continued, government must permit a prayer giver to address his or her own god or gods as conscience dictates, unfettered by what an administrator or judge considers to be non-sectarian. Now, all of this, up to this point, is fairly modest in nature. Kennedy is essentially expanding the Marsh versus Chambers exception for legislative prayer to include town boards. But the third move, I think, is the quite dramatic one. Kennedy, not surprisingly, uses his coercion test as the ultimate test for an Establishment Clause violation. This is important because what it means is that mere offense or discomfort at the expression of a religious view in a government setting is not enough. It is not enough for the religious outsider to feel just like that, as an outsider. This is something that the endorsement test was concerned with. But for Kennedy, so long as the government is not pressuring someone to abide by the majority's faith, then there's no problem. This coercion test in effect, licenses judges, licenses naked judicial discretion to say what coercion is and what it isn't. True, there's nothing in the record that indicated that town board members granted zoning variances or handed out prizes to kids based on who stood during the prayer and who didn't. But I don't know if anything in the record in the high school football game case indicated explicitly that kids who didn't stand were expelled. Justice Kennedy was able to empathize in the football case quite easily. He was able to understand that the 14-year-old trumpet player in the band who doesn't accept Christ as her Savior feels immense pressure to pretend that she does when everyone else stands, heads bowed before kickoff. There was no such empathy displayed in Town of Greece. Should non-believers choose to exit the room during a prayer they find distasteful, Kennedy writes, their absence will not stand out as disrespectful or even noteworthy. Really, in a town of 10 people, a room of 10 people in a small town, would a Jew seeking a zoning variance find it so easy, so non-coercive, to walk out while people empowered to decide the variance stand with heads bowed? Justice Kennedy's coercion test leaves a lot of room for religion in the public square, far more than just in legislatures and in town boards. A lot of room for people in the religious majority to make those of us in the religious minority feel deeply uncomfortable. Those of us who don't like having to swallow an undesired dose of sectarian religion are left with a thin reed against which to lean, a test for coercion that allows a judge of majoritarian faith to decide when we will or will not feel pressure. There's a revealing passage at the end of the opinion that gives me little faith in this empathy test. By inviting ministers to serve as chaplain for the month and welcoming them to the front of the room alongside civic leaders, the town is acknowledging the central place that religion and religious institutions hold in the lives of those present. But it isn't the central place that religion holds in the lives of those present, but the lives of most of those present. To my mind, the Establishment Clause is not there to make most of those present feel validated. It is to protect some of those present from most of those present. What's frustrating about the court's Tariff Phobia is how selective it is. We get justices screaming about lost liberty all the time, except where liberty, the liberty of religious dissenters, is actually lost. Okay, Tony.
Well, you know, I don't even think it's about, though it's definitely about protecting the minority, members of minority religions. As a member of a majority religion, I find it deeply offensive and disturbing and discomforting. And I think that that's part of the discussion as well, the idea that everybody's into this because a majority of people in this town of Greece allegedly belong to are Christian. Statistics that I found problematic from the get-go. But let's break this down a little bit more. This is not a small potatoes case. I think that it's what Kennedy actually says is only a pattern of prayer over time that denigrates or proselytizes is coercive enough. Only a pattern of prayer over time that denigrates or proselytizes is coercive enough. Wow. Mere offense is not coercion, seeming to move into free speech land rather than Establishment Clause land, and using language that, you know, one man's vulgarity almost, and avert your eyes. It's not even if the city council members lead the prayer, it wouldn't have necessarily offended the test that Kennedy applies here. I think that calling this a legislative prayer is, for the reasons that Dave already gave, a really thin line that they're drawing in description. Even if children are present, the court says not a problem if children happen to be present. And it's, yes, in adults about to petition their government. I remember when I was dean being up at the dedication of the Sandra Day O'Connor Courthouse, which began with a prayer. And everybody studiously, a prayer, the content of which would not have offended me in the least in a different context. But in that context, I thought, this is a legal gathering, and we're starting with a prayer to dedicate this building. And I wondered, maybe I'm the minority of Christians who would have thought that this was really out of register, unnecessary, in the wrong place for that type of bordering on sectarian address. And there were, as Justice Kagan's dissent, which I liked, but I thought she should have gone much farther, even if facing the audience, not the council. They're not appealing to the members of the council here, they're appealing to the audience by their body language. Believe this is not a problem. It would be rude for them to stand in some other place. So it can be explicitly sectarian, and there can be a pattern that was almost never interrupted, of one religion, the majority religion of this town, and those officials from those religions speaking. And very weak to no effort to really draw in non-majority religions, and in the aftermath, to the extent that they're going to be drawn in, they need apparently to not be members of the Universalist Church online, which you can become a minister in order to officiate a wedding, as I'm going to do in a few weeks for my niece. No, that wouldn't count. It needs to apparently be a real church or a temple or whatever. I mean, this is really a problem. Even if you were going to cordon it off and say, well, the legislative prayer thing. And I don't think it's clear at all that this is just a plumping up of the bizarre but historically accepted legislative prayer exception. I think that this is potentially, for the reasons that Dave gave, an important, potentially tectonic shift. Because look at all the theories they could have used. As he said, they could have gone, Justice Thomas thinks that the Establishment Clause doesn't apply to the states at all. It's just a federalism mechanism. That got one vote. The hard coercion, Scalia approach, you have to kneel before the government before there's an Establishment Clause violation. That got 2 votes. The softer coercion, which was coined by Justice Kennedy in one of these prayer cases, wins here, though he's giving more beef to the coercion test, and it has to be pretty darn coercive, I think. Gone by the boards is Justice O'Connor's non-endorsement test. It gets very little to no attention here. The Lemon test, they've been trying to squeeze the life out of it forever, and there are problems with it. It's true. But guess what's completely missing? The strict separation of church and state. It's been gone for decades. There's not one member of the current court, not one, who endorses anything like a true strict separation of church and state. And yet we have trope after trope after trope of the war on Christmas and the war on Christians. And I have to say, if there is one, it's not being conducted by the United States Supreme Court, or the troops are really, really tiny troops. I mean, really tiny troops. If this were a free speech case, just think about it. Government provides one microphone. And it says, we're going to provide the microphone and you can speak, but you can only speak during this time, this mic. Okay? And it all the time has limited forum scenarios. So you can speak in that mic, but it can only be, and here's our criteria, it's a religious moment. And we will encourage people from different faiths to come and speak only on one topic, religion. But don't proselytize. And don't denigrate members of the other faith. Now that's a viewpoint specific within the subject matter crafting of what you can and cannot say on a specific topic that would never fly in the free speech area. And it's so dismissive, I think, of devout Christianity. You know, the idea that if I were to get up and say that Jesus Christ is the Savior, etc., any good trained Sunday school kid hears in that, and if I don't, I'm feeling a little toasty. That, you know, it's not what they must have in mind. Maybe what they have in mind are the funeral protesters in the Westboro Baptist Church saying we couldn't have that, right? We couldn't have them come to the microphone and give their version of Christianity. Well, if you stopped it at that point, see, you're editorializing based on viewpoint, based on your sense that that prayer is vulgar, based on your sense that that prayer is inappropriate to the occasion. And all of that's incredibly problematic if you believe in a kind of robust liberty for religious expression, which I do, but it's a time, manner, place kind of thing. And the time and the place and the manner, the mistake, all that occurs in nature, the naturalistic fallacy, is not good. Just because something's always been doesn't make it right. And I think that some things seem congenial and all right when we're resonating and moving somewhat to the prayer, but I can tell you as someone for whom the contents of the prayer are not particularly jarring, the context of the prayer is. And there's an alternative. It's not saying that you can't, they could have had a moment of silence. And I think that would have been acceptable. They could have done a lot of other things, as Justice Breyer says, but instead they chose to approve what this particular jurisdiction did. And I think it's more problematic than it looks like even if you just stay within the majoritarian, especially if you stay within majoritarian religion. Historically, we should have learned better. Historically, if we're going to go to colonial days, there were religious people who understood that separation of church and state was essential to protecting, not state, but church. right? That keeping this kind of tolerance in space was the best way to preserve the power and recognition. When the Catholics spun off of the public schools, the chronicles of the Catholic departure from public schools wasn't because there wasn't parent school, but because the version of the Bible that was being used in school departed from what the Catholics believed. And so they spun out because they had a disagreement with the Protestants. In the last 30 years, there have only been, by my count, I think maybe 4 or 5 cases in which the Establishment Clause argument has won. It's the ever incredible shrinking Establishment Clause. It's getting smaller and smaller and smaller. And I think it's important for people to recognize that this is another move in which it's gotten smaller still. Now you might go, yay, terrific, that's great. There's no break. Let's leave it to the political process. I think that's dreadful. I think that there were early stage religious believers who understood it was dreadful. I think that the minister from Missouri, who was on the Senate Judiciary Committee, Danforth, he totally understood this and wrote a beautiful editorial about it and the importance of preserving separation of church and state. So I think that Kennedy assuming that these were not denigrating proselytizing prayers is wrong. His bowing here to tradition is highly problematic. Plus, it's the state, not the federal government, so the tradition we should be bowing to should be post-1868 when the Due Process Clause was adopted, not again when we're running around in the tri-cornered hats. And I think that it's a mistake. I think that Justice O'Connor's absence is like a man's hat, felt. And I think that when she said, why would we trade a system that served others so poorly, one that served us well for one that served others so poorly, I think she was right. I think the substitution of Justice Alito for Justice O'Connor on this was the most important thing to see coming down the pike. And I think it's just a matter of time before we shift so far away from separation of church and state that these sorts of things will become de rigueur. They had a choice. There's nothing essential about opening a city council meeting with a prayer. And to that I'd say, amen.
Well, the specific demand in this case was that the town take affirmative steps to reduce the Christian sectarian character of the prayers and of their direction to the public. There was not a direct attack on legislative prayer itself. And perhaps we could state it alternatively. The question is whether the difference of public participation in town council meetings requires efforts at sectarianism, at non-sectarianism, that legislative prayer may not. In this case, many of these prayers were directed to the public in attendance, and the council's visual observance was apparent. And the dissent says that about 2/3 of the prayers that were given over this 10, 11-year period fit this character. Another way to put it is the real issue is whether those differences amount to sufficient coercions of work used. I don't know that coercion really should be the right word, because that suggests a high standard that might itself not be respectful enough of different people's sensitivities. And the court says, in a rather summary way, that the purpose of this is to lend gravity to the audience, and they're talking to the council members, not to the public. And people should understand that. If they don't understand that, they can get up and walk out and come back afterwards, or they can plan to arise after the prayer is done, which is very, very dismissive of other people's sensitivity. I think Justice Kagan's dissent makes a compelling case that the court's opinion simply disregards the facts. It does not come to grips with the actual facts of this case. One might conclude that those facts do not compel a different result, but they just appear to be not dealt with in the majority opinion. I will offer some possible takeaways from this. One possible takeaway is the court declined to engage the true record and true facts. Perhaps they're favoring a bright line cut off to avoid fact-specific litigation in the future. Maybe they don't think there's enough of a problem here to warrant the expenditure of judicial resources or expenditure of the Supreme Court's public credit stop at it. Justice Kagan kind of refers to this in her dissent, where she says, well, maybe what they're really saying is, what's the big deal anyway? Or there's another possible takeaway here, and that is that the court majority thinks this is just fine. And I guess there's a fourth possible takeaway that really, in my view, fits the Hobby Lobby case a little better, so I'll save it for my remarks on that. I do have a concluding thought, and I aim this thought at our law students here, and that has to do with the lawyer's role. I couldn't help reading this without thinking about the lawyer's role in these matters. Let's go back to the beginnings. There's the three things the lawyers do for a client is, first of all, you help the client identify and understand the benefits and costs of proposed courses of action. And number two, you help the client make a decision, a choice of what course of action to pursue. And then, depending on that choice, you do devise and pursue strategies to achieve the client's chosen goals, which may include advocacy. This conduct in the litigation that it brought does not pass a cost-benefit analysis as most people would see it. What are those costs and benefits? First, no one requested these prayers. One council member thought of it on his own. So there's no public demand that's being satisfied by this conduct. Number two, offense to some people and discomfort to even more is certain. Next, controversy is likely that is unrelated to the town's functions. And once demand is made and litigation is threatened, great expense is a certainty, with a risk of double expense if the case is lost and the plaintiff's attorney's fees are assessed against the town. I think most people would conclude that there's no benefit to the town's public mission from the great monetary and non-monetary costs and risks of having pursued this course of action. And again, I speak to the students as a lawyer. You would probably advise the town not to continue this conduct or to litigate it. Now, the town won this case, but was it worth the risk? This was playing Russian roulette for a dollar bet. The event that the bullet did not roll into the chamber does not mean that it was sensible to take this risk. And so for every client, you will be counselor before you become advocate, and the most important advice you give is whether the client should even engage you as an advocate.
I would echo a lot of these thoughts. A couple of additional thoughts that I had. The first was that when I was at the oral argument in this case, one of the things that struck me over and over again was that even for the justices who eventually wound up in the dissent, that the idea of not having the prayer was never on the table. That this is so woven into the fabric of our society that was just not anywhere that anyone was going to go, even the dissenting justices. And the Obama administration was on the town side in this case, including because of the long history of legislative prayers in Congress. And so this was another one of these cases where it struck me as that there was no sense that the Supreme Court granted cert to tell the Second Circuit what a great job it had done, and it was just a question of where it was going to go. Like Tony, I was really struck by the decision, though, at how high a bar Justice Kennedy's test sets. The idea that there's a pattern of prayers that over time denigrate, proselytize, or betray an impermissible government purpose, based solely on the content of a prayer. I mean, in this case, they had, admittedly sectarian prayers for 8 years before they switched over only as a result of complaints. And so that's not a pattern because, according to the majority, there was no denigration or proselytizing. But I will note that, to a certain extent, maybe some of this is in the eye of the beholder. After the complaints were made, the record shows that some of the prayer givers did essentially denigrate the people who were complaining about the prayers. There's language about, those who are ignorant of our history, help them, please. And so I think that, to Judge Wake's point about sort of what was going on here, I think a lot of this, and this is something that I'll talk about a little bit with Hobby Lobby too, just boils down to two very different sets of worldviews on behalf of the justices. I don't want to say it's as simple as Christian and Catholic and Jewish, but more sort of the majority, the Catholics on the court are, they've always been on the inside, and the justices in the dissent, Justice Kagan, who was the first woman to have a bat mitzvah at her synagogue, Justice Breyer and Justice Ginsburg are Jewish. Justice Ginsburg was a female lawyer who went to Harvard Law School at a time when you had to justify your presence to the dean there, who couldn't get a job because she was a woman and a mother and she was Jewish. And Justice Sotomayor, who's a Catholic, I'm not sure whether she's a practicing Catholic, but she certainly has an experience as being an outsider. And I think they just really were sort of talking apples and oranges at each other. One person's coercion is another person's, what's the big deal here? And even to something as simple as Justice Kennedy's discussion of, in a room full of 10 people, you can always get up and leave. And the idea that would carry no consequences. I think, different people have different experiences with that sort of thing. I will note that in a lot of these school prayer cases, one of which the court denied certain, and I'll talk about that in a second, right at the end of, after the decision in Town of Greece, the plaintiffs in these cases are always does. They rarely these days bring the lawsuits in their own names because of the disapproval that they get from the community when they bring these kinds of lawsuits. So the idea that you can just stand up and leave and there's not going to be any repercussions, I think is something that different people obviously have different experiences about. Judge Wake, your point about the lawyers, and I guess to return to the idea of the high test that Justice Kennedy's decision set, I mean, it also just struck me the idea that you need a pattern, and so if you had, it sounds like maybe, 5 or 6 prayers that did all of these things, would that be enough to establish a pattern? Or your constitutional rights can go by the wayside as long as they're not going by the wayside on a regular basis. Justice Alito had kind of an unusual concurring opinion that was there mostly to sort of nitpick with some of the points that Justice Kagan made in her dissent. A couple of the things that struck me, and this sort of goes to your point, Judge Wake, about the lawyers, was, he said, to a certain extent, Justice Kagan's dissent boils down to the idea that they didn't really do a very good job choosing their prayer givers, but we're going to give them a pass on this, in essence, because they're a small town and they don't have a lot of resources. And he said something very similar about the lawyers. They may or may not have a lawyer on staff. This is a lawyer who's probably going to be more familiar with land use regulation and zoning than with constitutional law. And so in essence, he almost seemed to be suggesting, I don't think he intended to, but you can sort of take away an inference that to a certain extent your constitutional rights also depend on whether or not you live in a small town or a large town. Finally, as I said, a week or so after the court issued its decision in this case, it issued its decision in a case called Elmbrook School versus Doe. And the question in that case was whether or not it violates the Constitution for a public high school to hold its graduation ceremony in a large church, because that is, in essence, the biggest auditorium in the area. The Seventh Circuit said, yes, that does actually violate the Constitution. The court held on to that case for a long time, didn't act on the cert petition while it waited to issue the decision in Town of Greece. It eventually turned down the cert petition, so the Seventh Circuit's decision stands. And so, we're left with a very high bar, it sounds like, for adults in legislative prayer. School prayer, the bar is perhaps not as high, but somewhere in between. And so, I do agree that this is a very important case. I have the sense that this is going to be a case where the court may be content, having issued these 2 decisions, to sort of sit back for a couple of years and let things play out before it takes up this issue again.
I'll just make 2 very quick points in closing. The first is that once you accept Marsh versus Chambers as the starting point for the analysis in this case, a lot of very difficult line-drawing problems arise. And all 9 justices accept Marsh as the starting point in this case. This requires them to decide what constitutes a legislative proceeding and what doesn't. Where do we draw the line between a true legislative proceeding, like the one at issue in Marsh, and a quasi-adjudicative proceeding, which is how the dissent attempts to characterize at least portions of the city council meeting. And once we get past that hurdle, we face, and I think all 9 justices had to grapple in one way or another, with an even more daunting hurdle, which is how do we place limits? How does a court or how does a legislature place limits on the contents of a pre-legislative prayer without censoring or micromanaging the content of the speech of the outside religious speakers who are being invited to give these prayers. And I think it was the very different reactions of the majority and the dissenting justices as they confronted this second dilemma that explains the divide in the case, or does the most to explain the divide in the case. The majority justices are extremely reluctant to require much at all of the city council or of lower courts or themselves in future cases in the way of policing the content of these legislative prayers, either individually or over the run of cases, to guard against the sorts of offense, the sorts of symbolic disenfranchisement that sectarian prayers seem to inflict or impose on religious minorities or non-believers. To them, the cost of censoring religious speech or chilling religious speech or entangling courts and legislatures with religious speech in those ways seems to obviously exceed any benefits that might result, any constitutional benefits that might result to religious minorities and non-believers. I think that Amy quite plausibly ascribes this view to the fact that all of the majority justices have spent their lives as, at least in a religious sense, predominantly as cultural insiders, although obviously there are different dimensions to each of their identities. The second point I think that bears note about the case, although obviously this is really a footnote to what has already been said, much of which I also endorse, is how close the positions of the dissent and the majority are here. This is another point that Justice Alito makes in his dissent. For all of the dramatic rhetoric, and I think the effective use of hypotheticals in Justice Kagan's dissent to demonstrate the problematic nature, designed to underscore the problematic nature of government entanglement with religion and government endorsement of religion, the dissenters not only accept Marsh versus Chambers and the constitutional permissibility of legislative prayer, not only accept the extension of that principle to the context of city council meetings like this one, but basically accept the practice that the town of Greece has engaged in of soliciting community participation, so long as that participation reflects the actual diversity of religious views within the community. That is a pretty weak constraint in itself on the kinds of constitutional harms that the other panelists have spoken about quite eloquently here, and maybe is simply a testament to Tony's earlier point that this is a court on which there are zero strict separationists, and in fact a court on which all 9 justices have pretty expansive views relative, at least to some justices past, about the appropriate role of religion in the public square.
Okay, we have 5 minutes left in the session, so why don't we take a couple of questions?
On the other side of things, monuments and everything else of religious nature on civil grounds always seem to be getting struck down don't know Ernie Chambers, he is a character. You either love him or you dislike him. Picture your legislature up here, and then picture one of the guys showing up in t-shirts and jeans. That's Ernie Chambers, and he does that. The last crazy thing he did was sue God.
Oh, he was the one who sued God.
And you think service was a problem in that, but he's persuaded the judge that if God is omnipresent and omnipotent, he knows he's being sued. I never knew whatever happened after that. But anyway, do you think this is similar to balancing, since all the monuments and all the other Ten Commandments and everything else are being removed from public life, this is somewhat, will give you this?
Okay. First of all, I can't help but make a joke. There's a play, Sister Mary Ignatius explains it all to you, and she's got the little note cards up on the stage and answers the audience questions, and one is, does God always answer your prayers? And she says, why, yes, it's just that the answer is usually no. And then, it's not true that all these things have been taken away. That's the trope I'm fighting. There was a case in which they said the Ten Commandments, there's a standalone Ten Commandments on public ground was upheld, and in a companion case where the Ten Commandments were put in a different setting, and after counsel tried and tried and tried to get them to give a more ecumenical or secular explanation for the Ten Commandments, they insisted, no, Jesus Christ, Prince of Ethics, the record was so bad of the sectarian purpose that Ten Commandments stood. Also, there isn't one Ten Commandments. The Decalogue comes in different versions. And so even when they agree to have the Ten Commandments, which has been upheld, those of you probably know, it's a version of the Ten Commandments. But Ten Commandments were upheld, okay? They upheld firing a minister for suing for a disability under the ministerial exception, 9-zip. They've upheld state-paid teachers on school grounds of religious schools to assist disabled students. They've upheld state-paid interpreters to go into South Point High School, which is a Catholic high school here in Tucson. They've upheld granting, as we're going to see, for-profit businesses exemption from general rules based on their religious convictions. They've upheld student prayer on public university grounds. And that was years ago. They've upheld after-school student prayer groups. And they've upheld funding for student newspapers that assert religious views. The number of cases since the 80s in which an Establishment Clause argument has been made and won, I believe N equals 5. It is just not true. It goes crazy. What is true is that within certain enclaves like public school classrooms, if you have a fixed Ten Commandments or something of that sort, there's case law that has been respected where in those zones the religious symbolism is seen to be too much with the imprimatur of the state. But The Naked Public Square, a terrific book concerned about this, that we don't want our secular life to bristle with all hostility to all things religious. One. It's over. One. Unless what you want is the whole enchilada. That what it's really about is getting prayer back in school. And we've been there. As I say, if knowing some history does help. So I'm glad they said that prayer in the town of Greece. Pity those who don't know the history, because the history would make you wary of one particular version of the Bible, one particular version of the Decalogue, of any of those. Those are sectarian, not just religious, but sectarian images. But it isn't true that the United States Supreme Court has been captured by godless secular humanists who have been stripping the public sphere of religion. Vouchers is a huge amount of public resources, not-for-profit status for churches, etc. No Establishment Clause violation. Hobby Lobby, as we're going to see, segue to Hobby Lobby. No Establishment Clause violation. Some arguments made, but the court doesn't give very short shrift to any concern that the Establishment Clause might be violated by providing this exemption.
Thank you.
Yeah.
Well, let's turn to Hobby Lobby. I think we will have time at the end of this discussion to talk more about Town of Greece or Hobby Lobby or any of these other cases. So I'm hopeful that we will have that time. But with that interest in mind, we'll just go ahead and get started. What are we to make of Burwell versus Hobby Lobby stores? A decision invalidating the so-called contraception mandate in the Affordable Care Act, or what its detractors derisively call Obamacare. Is Hobby Lobby a harbinger of a death by 1,000 cuts, demolition of the Affordable Care Act? Recall 2 summers ago the stunning decision by the Chief Justice, writing for a 5-justice majority, voting to uphold the employer mandate centerpiece of the Act. Was NFIB v. Sibelius just a Potemkin village of moderation masking a longer-term plan to gut the Act with a series of less visible decisions? Or is Hobby Lobby a temperate, measured decision that starkly illuminates just how much Justice Kennedy restrains his more conservative brethren? In Hobby Lobby, the court split 5-4. Held that the Religious Freedom Restoration Act exempted a closely held corporation professing religious beliefs from the mandate under the Affordable Care Act that all large employers purchase health insurance for their employees that covers contraception at no cost to the employee. I have no idea what the public policy significance of Hobby Lobby is, although this blissful ignorance will not stop me from opining on the public policy significance that Hobby Lobby has. To my mind, Hobby Lobby may well be the harbinger of the death by 1,000 cuts. There are 3 important pieces to the Hobby Lobby puzzle. The first involves Hobby Lobby itself. In 1970, a man named David Green borrowed $600 to start manufacturing arts and crafts products in Oklahoma City. 2 years later, he opened a 300-square-foot store. 42 years after, well, it was good timing. A bead-buying craze among hippies made the arts and crafts business extremely profitable. This is true. 42 years after the hippies started buying the beads, David's store grew into Hobby Lobby, the Hobby Lobby Leviathan, a corporation with 520 stores in 42 states, 22,000 employees, and $3 billion in annual sales. This explosion in growth has made David and his family extraordinarily wealthy. David is the 79th richest man in the world. He and his family own 100% of Hobby Lobby, a closely held corporation. Now, David Green is a devout evangelical Christian. He draws no distinction between his spiritual life and his business life. His business is an extension of himself, he believes, and he must operate his business in accordance with Christian principles. Hence, David was offended by the so-called contraception mandate, the second piece of the Hobby Lobby puzzle. The Affordable Care Act requires employers with 50 or more full-time employees to purchase insurance plans for their employees that provide what the Act calls minimal essential coverage. This minimal essential coverage includes preventive care and screenings for women that must be provided at no cost to the insured. Pursuant to regulations adopted by HHS, preventive care and screenings in turn includes all forms of FDA-approved contraception. Hence, a female employee of a large firm can get birth control pills, for example, without having to pay a copay. An employer who fails to pay for this coverage faces a $2,000 per employee penalty. The problem for David Green was that the FDA-approved contraception includes the so-called morning after pill, other forms of birth control like IUDs, that Green believes causes abortions. The morning after pill sometimes works by preventing a fertilized egg from implanting in the uterine lining. Green believes that life begins at fertilization, hence the morning after pill effectively causes an abortion. Now, the scientific consensus seems to be that an embryo is not an embryo until implantation, but Green believes otherwise, and many others of a religious bent agree with him. Hence, the contraception mandate, Green believes, requires that Hobby Lobby, the company he owns 100% of, must buy its employees health insurance that in effect subsidizes abortions. The third piece of the puzzle is the Religious Freedom Restoration Act, or RFRA. Until 1960 or so, someone with a religious objection to a law of general applicability would have nowhere to turn to find protection. But starting in 1963, the Supreme Court began to assemble a body of law under the Free Exercise Clause of the First Amendment that subjected laws ostensibly burdening religion to strict scrutiny. This case law entitled a believer to an exemption from an offending law, unless denying the exemption was the least restrictive means of serving a compelling governmental interest. As applied, this strict scrutiny proved to be strict in theory, but gentle in fact. The government won most cases. And in 1990, the court basically gave up on strict scrutiny altogether when it decided Employment Division versus Smith, holding that so long as a law is generally applicable to all people and does not overtly discriminate against religious objectors, it is constitutional. Congress went crazy and in 1993 passed RFRA. Now here's a fun game. Try to think of a bill that would have been harder for a member of Congress to vote against than the Religious Freedom Restoration Act. I came up with the Give American Soldiers Free Tickets to Baseball Game Act and the American Moms Make Great Apple Pie Act. RFRA passed the House unanimously in the Senate by a 97-3 vote. The justices in Hobby Lobby bickered over just what RFRA was intended to do, but basically the idea is to protect by statute what the First Amendment had protected before Employment Division versus Smith. RFRA subjects all laws that burden religion to strict scrutiny. Let me quote the applicable parts of the statute. Government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general application. If government does so, then the person is entitled to an exemption from the law unless the government demonstrates that application of the burden to the person, number one, is in furtherance of a compelling governmental interest, and number two, is the least restrictive means of furthering that compelling governmental interest. The Hobby Lobby case in sum required the court to answer 4 questions. First, is Hobby Lobby even covered by RFRA? Is a closely held corporation a person within the meaning of RFRA and therefore benefited by the protection the statute affords religious beliefs? Recall RFRA's text. Government shall not substantially burden a person's free exercise of religion. Is a closely held corporation a person? Justice Alito, writing for the majority, said this is an easy question. The Federal Dictionary Act applies to determine the meaning of any statute unless the context indicates otherwise. The Dictionary Act defines person to include a corporation. This is easy peasy. Corporations are persons for the purposes of RFRA. But wait, what about context? The Dictionary Act applies unless the context indicates otherwise. Surely context matters here. How can a closely held corporation engage in the free exercise of religion? Corporations don't exercise religion, do they? Justice Alito doesn't really answer this question. He answers with a little misdirection. Everyone agrees that RFRA applies to nonprofit corporations like churches, and how could we possibly interpret the word person in a statute to include nonprofit corporations but exclude for-profit corporations? Now, this argument is quite weak when Justice Ginsburg raises the possibility of a big publicly traded corporation invoking newly discovered religious beliefs to get out from under onerous federal regulations. Justice Alito dismisses her cavalierly. We're only holding that closely held corporations are persons for the purposes of RFRA, not publicly traded ones. But what conceivable basis does the Dictionary Act, the text of the Dictionary Act, offer to distinguish between closely held corporations and publicly traded corporations? If RFRA must apply to Hobby Lobby because there's no way to draw a legally defensible line between it and, say, a church, then why is the line so much easier to draw between Hobby Lobby, the closely held corporation, and Michaels, the publicly traded one? Second question, does the contraception mandate substantially burden Hobby Lobby's exercise of religion? This one was easy for Justice Alito. If Hobby Lobby doesn't pay the insurance, pay for the insurance plans, then it suffers a $2,000 per employee penalty. Third question, does the contraception mandate further a compelling government interest? Now here, Justice Alito can barely contain himself. There are lots of exceptions in the mandate for different kinds of plans that don't cover contraception. How can it be that providing free contraception to women is so compelling if there are so many such exceptions? But Justice Alito had to agree that the contraception mandate did qualify, that there is a compelling governmental interest served by it, lest he risk losing Justice Kennedy's vote. Justice Kennedy wrote a short concurring opinion underscoring his belief that the mandate does serve this sort of interest, to protect women's health and reduce inequalities in the cost of health care between men and women. In order to keep Justice Kennedy's concurring opinion from being sort of the takeaway opinion from the case, Justice Alito had to agree with him, had to accept that providing contraception serves a compelling governmental interest. Fourth question, is mandating that employers buy insurance covering contraception the least restrictive means of furthering the government's interest? Now here's where I start to worry about the death by 1,000 cuts. There are 2 ways the government can protect women's health, get them access to no-cost contraception without imposing this burden on religious companies, Justice Alito suggests. First, the government can simply provide the contraception itself. So we should have a single-payer system for women's health, in other words. Now this strikes me as so ridiculous that I don't think Justice Alito really wanted to rely upon it. So he identifies a second way to accomplish this interest. This is something that HHS already includes as an exemption for religious nonprofit employers. Religious nonprofit employers can just sign a certification saying that we object to providing contraception coverage. Upon receipt of this certification, an insurance company that's providing insurance to these employees is now obliged to provide the coverage for contraception for free itself. The employer is no longer paying for the coverage, so all seems fine. This is the lesser restrictive means of accomplishing the compelling government interest. But wait, a few days after Hobby Lobby, Wheaton College, a religious employer covered by the exemption, asked for an emergency injunction from the Supreme Court. Wheaton said that by filling out the certification form, it would trigger a process that in the end would ultimately provide free contraception to the employee. This is enough of a burden. This is enough to burden its free exercise of religion, even if the certification form itself absolves Wheaton of any financial responsibility for paying for the contraception. Relying on Justice Alito's opinion, the Seventh Circuit denied the injunction. Wheaton went to the Supremes and got relief. The Supreme Court is supposed to grant sort of temporary relief pending the merits decision only when the legal rights at issue are indisputably clear. So a few days after invoking the certification process as a less restrictive alternative, Justice Alito signed on to an order enjoining the certification process, suggesting that it indisputably clear that it violates Wheaton College's rights under RFRA. So what's coming then is a decision basically invalidating the contraception mandate. That's my guess. This is one of a number of other legal challenges to key planks of the Affordable Care Act. The D.C. Circuit will sit en banc, for instance, to decide a case of utmost importance to the success of the exchanges that are essential to the ability of individuals to buy their own health insurance. This case will likely go to the Supreme Court as well, giving the justices yet another chance to deal a body blow to Obamacare. The great victory for the administration of 2 years ago, a victory that supposedly heralded Chief Justice Roberts' statesmanship and moderation, is starting to look a lot more suspect now. So, Amy,
Am I going first? Okay. The day of the oral argument in Hobby Lobby, I got an email from a reader who had read Lyle Dennison's post, and she objected to his use of the word badgering to describe a couple of the female justices' questions for Paul Clement, who represented Hobby Lobby, because she said, it sounded sort of sexist, it sounded shrewish, and, the last thing that she wanted the news outlets to be doing was to be casting the female justices in a poor light, and she said this case is all about women's rights, and no one has been paying any attention to that fact. I think that it really boiled down to apples and oranges in terms of what the majority was talking about and what the dissent was talking about. The majority saw this as I think, a very narrow question about the rights of a closely held company to exercise religion, and the dissent saw this as really all about women's rights. And you can see this in Justice Ginsburg's dissent. She spends pages talking about the importance of birth control for women and how the mandate came to be. But there's not much of a discussion of this in the majority, which is really all about the rights of Hobby Lobby and Conestoga, the other company in the case. One of the things, and this is the sort of thing that you do when you spend your life focused on 9 people, in the weeks leading up to the decision in the Hobby Lobby case, everybody thought that the Chief Justice was going to write Hobby Lobby because he and Justice Alito had roughly the same number of opinions. He wound up with 7, Justice Alito wound up with 8. It could have easily gone the other way, but he decided as the senior justice in the majority that he wanted to assign it to Justice Alito, which I think to a certain extent he kept another case, Riley versus California, about whether or not police need a warrant to search your cell phone for himself, which I think to a certain extent suggests that he saw Riley as the more important case. And I genuinely think that the 5 justices in the majority, whether or not this is actually going to be a narrow decision is one thing. I tend to agree with the idea that this could wind up being death by 1,000 cuts, but they genuinely regarded it as a relatively narrow decision. And I think you can see that in Justice Kennedy's concurring opinion, which was the only concurring opinion he wrote during the entire year. He wrote it just to stress that this was a really narrow decision. I think that they left open a lot of questions that are now going to be litigated regarding other forms of birth control, regarding different forms of corporations, regarding different laws. But I think that they thought they were writing, in essence, a one ticket only. A couple of other things. With regard to the least restrictive means, the idea, which I agree that Justice Alito relied on heavily, that the government already had these exemptions, that the women could get birth control through other means. And one thing that was never quite clear to me, still remains a little bit unclear, is whether or not, because if you read the dissent talks about, the majority's decision leaves these women without access to birth control. And so there are two very different narratives going on here. One is that no problem, they're going to get birth control anyway. The other is they are not going to get birth control. And I still have not been able to figure out what the actual narrative is, but somebody seems to be getting it not quite right. The government has issued regulations, I think at the end of August, to try to deal with the situation created by Hobby Lobby, but it's still, I'm not sure where things are going forward, and I'm not sure whether the majority thought that the government could essentially sort of wiggle its nose and make coverage happen for the women who would no longer be covered. The Wheaton College order, which came just a couple of days after the term ended, it's about 10 pages. There is some very strong language in there from Justice Sotomayor. She says, because the court, the majority, had relied upon the existence of this accommodation as the least restrictive means to justify its holding, and now they're taking a step back and saying, well, we're not sure about this accommodation. The idea had been that Wheaton College could fill out a form certifying that it objected to paying for the coverage for its female employees, and that would be the exemption. And Wheaton College's argument was that filling out the form, even if it didn't have to pay for the coverage for its female employees, filling out the form was enough to make it complicit in providing the coverage, the access to birth control for its female employees. And so the order that came from the Wheaton College case said, well, it's enough if you write a letter to the government notifying them that you object to the coverage. You don't have to fill out the form. And so Justice Sotomayor pulled no punches in her order. She said, those who are bound by your decisions usually believe they can take us at our word. Not so today. And then in the weeks and months after the court's decision in Hobby Lobby, you had heard several interviews with Justice Ginsburg, who said quite explicitly, that the five justices in the majority just don't get it. And so, I think that the justices in the majority regarded it as a narrow decision, that it's not, in their view, that the startling breadth that Justice Ginsburg described, whether it actually is going to prove to be, I think is going to be something very interesting to watch.
I'll just make a couple of very quick points here. First, I thought I'd take the opportunity to clear up a question which really confused me when I first heard about this case, which is how can the Religious Freedom Restoration Act passed in 1996 trump the Affordable Care Act passed in 2010? Don't later statutes usually supplant earlier statutes? And the answer to this question, as the more careful listeners in the audience may have already picked up on, is that the so-called contraception mandate of the Affordable Care Act does not actually come directly from the statutory language of the Affordable Care Act. The statutory language simply requires that employers purchase health insurance for their employees, which covers preventive health care. The Department of Health and Human Services has later or subsequently promulgated regulations defining preventive health care to include a range of pharmaceutical and surgically implanted forms of birth control. And so RFRA is not, in this case, actually supplanting or trumping the statutory language of the Affordable Care Act. Instead, it is trumping the language of regulations which are promulgated by the Department of Health and Human Services, and which have a, in the hierarchy, the lexical hierarchy of the American legal system, a subordinate status to statutes like the Religious Freedom Restoration Act, which are adopted by Congress. Second point I wanted to make here has to do with an element of the Religious Freedom Restoration Act, the test established by the Religious Freedom Restoration Act, which I don't think has been mentioned yet. Maybe Dave mentioned it briefly in his introduction, which is that RFRA is triggered only when some governmental restriction on an individual's free exercise of religion represents a substantial burden on the exercise of religion. This tracks the language of the constitutional test that RFRA was adopted to reinstate, the constitutional test which Employment Division versus Smith overruled in 1990. And there are a couple of interesting things about this element of the RFRA test. The first is that Justice Scalia, in writing for the court in Employment Division versus Smith and holding that the free exercise clause did not entitle religious objectors to exemptions from otherwise generally applicable laws, offered as one justification for his ruling that the old standard, the application of strict scrutiny to generally applicable laws, would require the court to assess whether particular governmental laws substantially burdened adherents of different religious faiths, and that it was impossible for the court to engage in that kind of analysis without deeply entangling itself with the doctrines of the faiths in question, and that this was an inappropriate role for the court to fill, and a prudential reason, and possibly a constitutional reason, for rejecting the application of strict scrutiny in this context. But clearly, at the time that he wrote Employment Division versus Smith, Justice Scalia thought that the application of the strict scrutiny test, which RFRA ends up adopting, did require a grappling on the part of the court, a serious grappling on the part of the court with the extent of the burden imposed by the challenged law. Flash forward to Hobby Lobby, an opinion, a majority opinion, which Justice Scalia does not write but does join, and you will see the majority basically ignore the requirement, really a threshold requirement for the application of the strict scrutiny required by RFRA, that the challenged law, or in this case the challenged regulation, substantially burden the religious exercise of the plaintiffs. Instead, the court simply takes Hobby Lobby's word for it that a requirement that it subsidize insurance which covers contraception substantially burdens its religious exercise more, for example, than signing the paychecks which its employees use to purchase the same forms of birth control. And as a result, almost completely skips over this stage of the analysis. The stage of the analysis, incidentally, which the court most often relied on, or at least very frequently relied on in the pre-employment division versus Smith cases to prevent strict scrutiny of generally applicable laws that differentially burden religious exercise from wreaking havoc with all kinds of governmental requirements analogous to, all kinds of governmental regulations analogous to the contraceptives mandate.
That's right. The thrust of the opinion in 1990 by Justice Scalia was that it would leave democracy in shreds. That it would leave democracy in shreds. You know, and keep in mind that what's happening here isn't a question of whether they can engage in private religious conduct or our commitment to their private religious belief. Everybody understands, I think, that the move from our beliefs to our conduct to be a fully actualized religious person often requires conduct. But in a liberal democracy like ours, we have traditionally drawn the line at the conduct threshold. Problematically, to be sure, but we traditionally have. I think what's interesting about, there are a lot of things that are interesting about Hobby Lobby, but one is, first, keep in mind it's statutory. We could undo this. And it's insulating conduct. It's not just insulating belief, but conduct. And that puts it in a different category under traditional thinking about negative liberties versus positive liberties, and how far should we go. Third thing is it's covering for-profits, not just not-for-profits. And that is a big move in this arena. He cites one case, and I think that in that case, it's not clear to me that the court was focused on the distinction enough to make that case support the rest of the opinion. It's also doing something that in the race area is typically not done, at least not as a matter of constitutional law. It's giving protection from a neutral law of general applicability that the court absolutely concedes is advancing a compelling government purpose where there's no evidence that the law was passed to burden the religious beliefs or conduct of the owners of this commercial entity. There's no whiff of animus against them. It's one of these bad things that happens in a democracy, this disparate impact and it is a bad thing. But paying attention to the religious exceptionalism, that we have passed a statute and said it doesn't violate the Establishment Clause to give exceptional, way beyond constitutional protection to avoid the disparate impact of a neutral law that wasn't out to get you. We would not tolerate this these days with race. And I think that comparing these two should be comfort to those who worry that the court is inhospitable to race or that the majority is to religion, or that the majority is, that this was passed giving exceptional protection. It's not only adding protection that's way beyond what's constitutionally required, it's adding to an already significant protection that the law has traditionally given to religious actors. In the context of employers, though in the past worrying about the tension between the religious employer who wants to preserve its religiousness and laws of general applicability trying to protect us against discrimination or other public goods, they've given religious institutions acting as such, right, acting as a religious institution, the right to make religious-based hiring decisions, to favor co-religionists. Title VII has a carve-out where there's certain things that religious institutions can do that nobody else could do. It wouldn't allow a white employer to prefer white employees. It wouldn't allow a religious employer to prefer white employees. But it does allow a religious employer to prefer co-religionists. So it's, again, the backdrop is substantial protection of religious institutions even when they move out from the church and the temple and other enclaves and engage in commercial activity. And I think that's important. And it's giving, as Andy has said, vast power to the religious owners to say what is an interference with their religion. They get the right to say, it's the unbearable lightness of burden, in a way. I'm burdened. Why? Because a flip rule would be highly problematic. It's like telling the Boy Scouts, no, you don't. You don't tell the Boy Scouts what they can hold themselves as being, right? And they're permitted to say an out gay scoutmaster is inconsistent with our rules that say straight and clean, okay? Now, once that's a private association. If the Boy Scouts start selling things, opening themselves out more to commercial activity, that's traditionally where we've drawn the line. And we've drawn the line to commercial activities with respect to those who have private conduct commitments that are inconsistent with the general public in the context of civil rights, right? That there's the decision to operate in corporate form is a sacrifice of certain other commitments. And so that the rest of us don't have to check out in advance, looking behind the word Hobby Lobby, what kinds of rights I'm going to have if I work for you. Little Sisters of the Poor, I'm on fair warning, right? Hobby Lobby, not so much. I didn't know. Chick-fil-A, I didn't know in these other contexts. And so those of you who are libertarians, I'm not sure that this is a liberty victory at all. That even John Stuart Mill thought that the liberty victory ends once it's moved into conduct. Your liberty ends with my nose. And so I think that this is a very important case in showing you that tension, and where the government has given tremendous support to individual businesses, even those operating for profit, and way beyond what the Constitution would require, way beyond what Justice Scalia, interpreting the Constitution in the Peyote case, would require. Good thing, bad thing, big case, small case, we'll see. I think Amy's exactly right. Ira Lupu, who's written a tremendous amount on this, says what's going to happen here, it's going to be strict in theory, But as a practical matter, all these other concerns are going to start to reassert themselves. And judges interpreting this language that says substantial burden, compelling interest, and least restrictive, that would seem to protect this individual very, very maximally, that judges are going to interpret compelling interest liberally and narrowly tailored rarely in order to permit these laws of general application to move forward, notwithstanding religious dissent. Why? Because any other outcome is a patchwork. And some patchwork may be a good idea, but a civil rights patchwork, not so much. Not so much. So, as you can imagine, I'm heavily into crafts. And so I was glad to find out that I shouldn't go work for Hobby Lobby, though I'm also at an age where the specific issue is not very important to me, but it is to my nieces. So I think that it is an important case. But we'll see. Okay, Judge.
Just a few comments, then we take some questions. You can read this narrowly or broadly. The court states it's a narrow holding. The dissenters say that it's a broad holding. And the specific thing is whether for-profit corporations' exemption from paying for, including abortifacient contraceptives in their health care plan, whether that is a required exemption under the RFRA. Now, they admit it's and the RFRA requires for substantial burdens that there be a compelling interest for the reason to overcome it, and that the least restrictive means be used. And they assume that there's a compelling interest here, and they say, but you didn't do the least restrictive means to deal with this. Why not? Well, we've already got this accommodation for religions and religious corporations directly. And what's that accommodation? And I keep reading that, and I fear I'm not understanding, and I invite anyone to tell me where I'm getting it wrong. But it seems to be saying you're not going to have to pay for this because we're not going to make the employer pay for it. We're not going to make the employee pay for it. But the insurance company will pay for it. That's right. And you're already doing that for these denominated protected corporations. What's the big deal of extending it to for-profit corporations? Well, as Justice Kagan said in her dissent, this is a statement that the general public can just pick up the tab for the for-profit corporations. The opinion says, well, you know, HHS says this is free. There's no cost here. You said it's free. I'm not sure, but I think Justice Alito was careful not to say it's free. He's just saying that the government says it's free. Well, you know, when I was in college and taking my first semester course in economics, one of the fundamental principles that I was taught is there is no free lunch. Everything is paid for by somebody. It may not be paid by the person who uses and benefits it, but somebody pays for it. So I guess even though there is no free lunch, apparently there are free contraceptives. This really doesn't make much sense to me. The accommodation here is just have the taxpayers. Now, it may not be taxpayers. It's the insurance company. But the insurance companies, then they have to charge premiums to cover all their costs. So it's socializing the cost to... I found that part of it. Either I'm not understanding it or it really failed some basic tests on intellectual honesty.
I think that, this is what I've heard, and I'm, God knows, not a mathematical expert, but I think that as an actuarial matter, you know, the costs for the insurance company of providing the birth control, whether it's an IUD or pills or whatever, are vastly outweighed by the cost if a woman does not use one of those methods of birth control and becomes pregnant and they have to pay, you know, whatever, it's $4,000, $8,000.
Why isn't insurance free then? Anyway.
That I can't answer.
I agree. There seems to be some magical thinking about this. I would think that if the incentives are such that for an insurance company, it's so manifestly obvious to provide this coverage without any cost for free, that insurance companies would be, you know, like handing this stuff out in the park. I mean, it just seems like this would be. Why would we even need this law? Why wouldn't insurance companies do this already? Why wouldn't they insist that if you buy a plan from us, it must include free coverage?
And my best take on this, and again, I confess I may be mistaken, is that the government was being dishonest with the public when they said this for the people that they were mandating it, and the court was enjoying sticking the government with their own dishonesty for this expansion.
I think Amy is right, or certainly what Amy said is consistent with what I've read on this point about the actuarial costs of covering contraceptives. The problem is that actuarial calculation is in the aggregate. So in the aggregate, it's cheaper for insurers to cover contraceptives than it is for them to cover the accidental pregnancies that result when they don't cover them. The problem is that each individual insurance company has incentives and has ways to avoid covering the pregnancy and the contraceptives. Somebody is going to, under the Affordable Care Act, when all or nearly all Americans are insured, some insurer is going to foot the bill for the pregnancy. But that insurer may not be the same insurer who foots the bill for the contraceptives.
If that's the case, how is it that everybody else is somehow paying for these contraceptives? Because if that's true, nobody would pay for it because the cost is always covered by the long-term benefit. I'm not saying I know the answer. I'm just mystified by this logic.
Before we turn to the audience, I just want to say, so we don't get away from it, isn't Dave Marcus amazing?
I actually think there's one last point that we might make on the Hobby Lobby case.
One that's going to be even after that.
All right. So a number of the panelists have talked about whether this will turn out to be a narrow ruling or turn out to be a broad ruling. I think we may not have been clear enough about what a broad ruling would entail or what broad implications what the broader implications of this ruling might be. The broader implications that the court discusses and that the dissent discusses are principally in the healthcare context. So you can imagine employers who have religious objections to providing or participating in vaccinations, or employers who have religious objections to participating in or funding blood transfusions, raising similar objections. More broadly, if this ruling extends to the religious exercise of all closely held corporations, maybe even all publicly held corporations who are subject to generally applicable regulations which are, in their view, contrary to or in some sense burden their religious exercise, you could imagine challenges to employment discrimination laws. You could imagine challenges to public health laws. You could imagine challenges to all sorts of regulation, consumer regulation, which are intended to protect the general public, but which individual employers argue are, as applied to them, in conflict with their religious beliefs, substantially burden their religious beliefs, and therefore ought to be subject to strict scrutiny under the Religious Freedom and Restoration Act. And so when people worry about the potentially broad implications of this ruling, those are the kinds of things that they're worried about.
And I think we'll see a little bit of the Hobby Lobby decision coming up, and that the court's rationale in Hobby Lobby could have repercussions, beyond the healthcare context, beyond the closely held corporation context. There's a prison rights case called Holt versus Hobbs that's at the court this term, and the prisoner is represented by the Alliance Defending Freedom, who represented Hobby Lobby in throughout the litigation. And the question is whether or not this Muslim prisoner who believes that his religion compels him to have a beard can have a half-inch beard. And the state of Arkansas says no. It says that there are serious issues regarding safety and the operations of prisons, because if you have a half-inch beard, the prisoner could hide a razor blade, which could be used as a weapon. He could hide a SIM card for a cell phone, which could then be used to run drug trafficking operations from prison. And one of the interesting questions, so certainly that goes to the substantial burden question. Is this a substantial burden on his religion? But then when you also get to the least restrictive means prong of the test, and this is a case that's brought under not RFRA, but the Religious Land Use and Institutionalized Persons Act, but it has this similar test. The fact that 44 other states and the federal government allow beards. And so, does that demonstrate that there is in fact a least restrictive means? You can search the beard, you can make them search it, and so, this is going to be interesting to watch in the next couple of years, well beyond, healthcare and closely held corporations.
Well, I'm very glad that we have some time for questions from you all or thoughts from you all. So please, yes, up in the back.
I haven't read Hobby Lobby, but my question involves the pharmaceutical and their corporations, so they're people too. And what role would they have representing major corporations that supply, if any?
I didn't quite catch what role would who have in representing?
Pharmaceutical corporations that are also people that supply Berkeley.
Uh-huh. And I wonder if you could restate the question.
Well, I'm just wondering what role, if any, would they have in this Hobby Lobby case, since they have a huge financial interest?
So what role would pharmaceutical companies have in sort of the fallout from all of this, given the financial interest they have in
producing it, or in invoking RFRA to defend against the distribution of it, or
I didn't read the case, and maybe I'm just thinking things out loud and not making any sense, but I would think since they are people too, that they would have a corporate interest. And I don't know if they're
I think it would depend on a couple. It would depend on the sort of exactly what their objection was. Under the court's test, it would depend on.
nobody's buying I can't sell my product.
Yeah. Well, I wonder if
because my product is being forfeited under this.
Well, let me see if I can. So, I think one issue we didn't talk about in the Hobby Lobby case. I'm not entirely answering your question, but I think it kind of gets at one interesting question, which is what are the sort of spillover effects of this decision on privileging the religious views of closely held corporations? What are the effects on third parties? One argument made before, in leading up to the decision, was an Establishment Clause argument that, well, if we allow Hobby Lobby to invoke its religious objection to providing to paying for contraception coverage, are we sort of countenancing Hobby Lobby's religious belief and imposing that upon on employees, that is, a sort of third parties, who now have to sort of face the consequences of their employers' decisions. So that the employers say, we don't want to pay for this, but it's the employees who are now on whom the consequences of their religious objections are being visited. This is an interesting kind of wrangling over whether is this a Establishment Clause problem. I don't think much really came of it. I'm not really sure why. But it seems like there are many one could imagine many ways in which a company as large as Hobby Lobby, of such public importance, even though it's a private entity, giving it constitutional protection of this sort of belief could have ripple effects across in various ways, and whether this triggers any kind of Establishment Clause worries or not is well beyond my capacity to answer.
The broader implication of Hobby Lobby was primarily my question. How do you feel the Supreme Court would actually handle a case whereby a closely held Christian Scientist corporation objected to vaccination or surgical procedures, or in Hobby Lobby's case, there was concern that several women were pregnant or were engaged in relationships where they could become pregnant, and they objected to paying them a certain amount of money which would be equal to the amount of money that they would have to pay to get an abortion. And so they, notwithstanding wage and hour laws, or notwithstanding the Christian Scientist example, how do you think that, in view of Hobby Lobby, how do you think that the court would cut through that?
I think it's a great question, and I think it goes back to Amy's point, and everybody's about how narrowly would they read it. Justice Alito himself gives these examples or examples like it in the opinion to say, well, that way we wouldn't do that, right?
So what would they do?
Your guess is probably better than mine. He's in some of these contexts we've been trying to work out, even with respect to religious employers, what the extent is of the exemptions that they're already provided. with respect to preferring co-religionists over others. He's saying that there's not a good way to distinguish between the closely held and the religious corporations. And so, that's one can of worms that's open. But the biggest can of worms that's open is what's going to be sufficiently narrowly tailored. An irony is that in a lot of these laws, exemptions already are built in. And the exemptions were built in to give some breathing room. And now, I think a good lawyer is going to, or other practices of other jurisdictions, where you can find others, exemptions that exist, or other jurisdictions that have engaged in a different practice. I think your argument is much better now to say, and therefore this isn't narrowly tailored, and therefore you have to provide me that exemption as well. I think that there is a Pandora's box problem, in other words.
Because if Hobby Lobby has prevailed in this one narrow exception, there can be hundreds of narrow exceptions of the exact same principle.
Back to the pharmacy example, I think that it does suggest, well, I'll let the panel go, but the pharmacist who doesn't want to prescribe the drugs is a recurring theme in some of these cases, and to what extent you can opt out of professional rules or opt out of other general rules based on your religious convictions and refusal to serve customers, I think is definitely an implication of this set of cases, but their rejoinder will be, oh, we served them, they got their contraception, and they got it without paying copay. They were completely whole in this case. And in all the other examples that you're giving, somebody third party is going to be hurt much more than was the case here. And so I think that eventually I think that the courts will make much more of the point of how badly the third parties are hurt. They assume here they're not hurt at all. And so the bigger the hurt, the harder it's going to be for the religious actor, commercial actor, to justify inflicting the pain. At some point, they might even get to Dave's point, that inflicting that pain isn't an accommodation of religious freedom. It is an Establishment Clause violation. It's putting the price of your religious convictions on me. But the court alleviates that. There were briefs filed to that effect, but the court alleviates that analysis in this case.
Andy, did you want to?
Oh, I just think Justice Alito tries to be as clear as he can that we're not going to stop you from getting vaccinations. We're not going to stop you from getting blood transfusions. And there are, I think, two ways to understand that. One is that the court thinks blood transfusions and vaccinations are important or more important than birth control, or they think they're important and birth control is not important. Or another way to read it is that we don't think that holding for Hobby Lobby in this case is going to prevent anyone from getting birth control. We do think that holding for a religious objector to vaccinations or blood transfusions might be a serious obstacle to patients actually accessing or employees actually accessing those services, and that's a step that we're not willing to take.
Jim, did you have a question?
Yeah. Related to this, the implications of the decision. We have to keep in mind, don't we, that RFRA is limited to federal action, right? And so this Arkansas case.
Right. Yeah.
But that, I'm not sure how that plays out since RFRA is limited.
Sure. I mean, the test is the same under RLUIPA as RFRA. The substantial burden, compelling interest. It applies to prisoners and
land use decisions.
It was enacted after the court held that it didn't apply to the states, that RFRA didn't apply to the states, to fill in some of the gaps that were left by the court having struck down that portion of RFRA.
The argument was that there was a better record of states in those specific areas of violating people's religious freedoms, whereas
but as to those specific areas,
that's right.
Yeah.
We don't have RFRA restored to what Congress intended to
That's right.
to apply to all
Yeah.
this.
But many states have their own little RFRA laws.
Right. But that's a very interesting issue. The little RFRAs.
I just wanted to clarify that. And the other is that, and they were talking about federal administrative action, right? Or, well, to the extent some other statute applies to state action, it applies to state action all kinds. But in terms of its scope of coverage, RFRA scope of coverage, it applies to federal administrative action for the reasons that Andy referred to. Is
Federal administrative action and to federal laws adopted prior to 1996.
Right, prior to, okay. I just think that's an interesting observation to keep in mind. And then on the substantial burden issue, I'm recalling Judge Kaczynski's Ninth Circuit decision for the Ninth Circuit in the San Francisco case, where he applies RFRA, and on the substantial burden, essentially says what we're looking for is a penalty, and he reviews the pre-Smith decisions and finds that in each of those there was a penalty involved, some kind of penalty. And he said that in that all religious practitioners in the San Francisco Peaks case weren't going to exact any penalty for wastewater to be used on the mountain to produce snow. But here, can't you really fairly readily find that there's a penalty? In fact, it's called a penalty, right? You don't pay, you don't provide for the insurance that provides this coverage, and there's a penalty of $2,000 for the employee. And so, I'm not advocating that point of view. I'm just saying, isn't that a line that's been established, and or criteria that's been established that can be applied, or is being applied in a fairly straightforward manner? I think the ambiguity is when you say, okay, well, the problem is that this particular belief that providing for contraception is offensive to religion, where do you then draw lines there? But the court has been careful in saying it's not going to get into the issue of sincerity of belief. It almost defers to the practitioner, and then it turns to the burden on that belief. And here the burden would be the penalty.
But others can disagree, but I think that the $2,000 penalty was just sort of extra. I mean, I think for the court in Hobby Lobby, the most important thing was that they believed that they were participating, essentially complicit in abortion by providing this coverage. I mean, they discussed it. And the counter-argument, which was made at oral argument, was, well, you could actually, and I'm trying to remember, you could actually decline to provide health insurance at all, in which case it would be $2,000, but it would actually be less than the cost that you pay for an employee over the course of the year. But the court said that argument wasn't raised below. It was raised for the first time in the court, so we're not going to consider it.
The Marty Letterman.
So you're saying the criteria that Kaczynski points out in the San Francisco case really doesn't hold?
I wouldn't say that it doesn't hold. I think that for them it was not about the money. It was about the religious beliefs.
I see what you're saying. It's like it's almost like a timing issue. What I'm saying about the unbearable lightness of burden is that the religious person is given tremendous, and what would the scheme look like if he or she weren't? I get to say what my religion is. I get to say that's an interference with it. The point at which I declare there's a burden on my religion is very much, you defer to the religious person short of one thing, proof of sincerity. Okay, they have to be sincere, right? Then the next step is, okay, I've proven this burdens my religion. Now is government infringing it somehow? Is like this next step, the Kaczynski point. And he says, easy, you're going to be fined. But I think he's conflating the two a little bit. And I think that Amy's right. I mean, I think that the point would be, am I forced into some sort of compliance? And in which way am I forced into compliance? A lot of money? He says no-brainer, because look at all this money you're going to have to pay if you're forced into compliance. But the more
that's the justification behind the Smith rule, right?
The Smith rule or RFRA?
No, the Smith rule. We don't want to get into those questions, right?
Yes.
So when you say that this goes beyond what the Constitution provides, you essentially agreeing with the Scalia's decision in the Smith rule?
Smith is beaten up right and left. And as Dave said in the introduction, the Congress couldn't run fast enough to the steps to pass RFRA to undo it. Why? Left and right were aligned. The right, more religious freedom is a good thing. And the left, horrible decision where they're denying members of the Native American Church the right to ingest peyote for sacramental purposes when in other jurisdictions, so there was this like perfect storm of alignment. And so it looks like a very compelling tale that can be told to the left and right about religious freedom that was insufficiently protected by Justice Scalia. Right? Only Marcy Hamilton, looking like a nut, in this context says, well, this is very bad for liberty, very, very bad for liberty. And she said, you wait and see what could happen with a statute like this. But the revolution was stalled by City of Bernie, where they knock it out in the first place, and then they re-adopt, et cetera. And now we're seeing the lower courts, mostly the United States Supreme Court has looked at these things rarely, actually, and it does permit pretty significant carve-outs, or it could potentially permit pretty significant carve-outs. And that's what I was saying earlier. That could be a good thing or a bad thing. During the Civil Rights era, we thought it was a bad thing, especially for commercial entities deciding that the religious convictions would trump other commitments that have to do with civil rights. So it's applied to that context. I think it could be highly problematic if this were to get going in earnest. Justice Alito says, oh, we would never do this for race. He doesn't say race, gender, sexual orientation. I can see why he didn't say sexual orientation, but I think it's really interesting that he says the race exemption would clearly be there would be no race exemption for religious commercial actors. But leaving out gender, it might have been less threatening to me had he said race or gender at that point. I mean, I think there's a potential here for this to be referral walking.
I think we have time for one, possibly two more questions. Yes.
My firm has fielded hundreds, thousands of inquiries after this decision. It's about hospitals, drug chains, corporate matters, and employment stuff. People coming out of the woodworks now claiming they have sincere beliefs about, well, they don't have to do this for their employees or this or that. And I think it's going to create all sorts of chaos. A lot of it create a problem in the courts. You're going to see more litigation. And I had one guy similar to this guy, similar company. He supposedly had a sincere belief until I started asking him a few questions if he was being proposed by a good lawyer. And suddenly his sincere belief turned out to be a political belief. Does your daughter have contraceptive? What type of contraceptive does she use? Either as a $6 billion company. I said, you may get deposed on your sincere belief. And the government is accepting these sincere beliefs as if they're true. I don't believe they are, most of them, for a minute. I think they just don't like the health care law, and they're using it as a way to help try and dismantle and disrupt it. But think about if you really want to be tested on a sincere belief, you run a big, huge corporation, they start asking a lot of intrusive questions. You may not want to do that.
Just a couple of very quick reactions. I think one thing, Judge Wake is surely right that the Obama administration did not stand up for itself quite as aggressively as perhaps it ought to have done so, because it didn't want to start getting into the business of saying, really, you really believe that way? The other thing, though, I should say that just as my personal opinion in preparing for today's proceedings, I do believe that David Green of Hobby Lobby is absolutely sincere. I was impressed with what I read about his commitment to his worldview and the way that has affected the way he runs his business.
This is frequently litigated under our LUPA with prisoners asking for accommodations. Often it's diet or other things. And the case law on that pretty much says you've got to take that statement of sincere belief at face value. And the only thing I'm thinking of now that I recall to get around that is if you can see conduct, you can prove conduct that is inconsistent with that sincere belief. But how do you know that unless you do a whole bunch of discovery? So it's really not a useful criterion to limit misuse of the law.
Employment Title VII cases usually accept it as fact that there's a sincere belief. You might ask one question. But my sense is if you went beyond and started peeling at this with non-profit huge corporations, they might not all be sincere.
Let's have time for one last question.
Really quickly, going back to the strict separation of church and state, Professor Massar, you mentioned at least you see some existence of it in the public education sector, just a little bit of. Where else do you see it now? I mean, since all the justices, it's gone. coming up in decades, where do we see the strict separation of church and state these days? These are the 5 decisions, if that.
It's not even in, I mean, it's in the classroom. In public schools, after-school programs that are religious, the Lamb's Chapel case, that's perfectly fine. In colleges and universities, the use of the classroom, and rightly so, I would say, for religious organizations, perfectly fine. The strict separation of church and state is mostly a unicorn, in my opinion, as I was raised to think about what it is. And actually, as Justice O'Connor says in the voucher case, when you look at the history of financial support through not-for-profit status, et cetera, of religious institutions, you're not going to set up a religious school and say, hey, we're not going to provide you with fire, water, rescue services. And then so it begins. And drawing the line gets to be very, very difficult. It tends to be drawn in the case of aid to religion, where the content of the aid itself is sectarian. Like the government can be, any proselytizing can be ascribed to the government versus the interposition of an independent, free private agent. The law's a mess because coming up with an alternative way of talking about where the line should be drawn is tough. And because our history, Andy made this point, you have a giant stable of outcomes that we've become used to. You're going to overrule all of them, or try to come up with some theory to keep them in their box. And so the answer is almost nowhere, in my opinion. I don't think the separation of church and state, maybe it never was.
Well, thank you all very much for coming this afternoon. It's been a long afternoon. We appreciate your attention.
Thanks to the panelists, to the amazing Professor Marcus,
I'm going to read your blog.
Bernadette Wilkinson, who's sitting back there. Special shout out. And Emily Caton, I don't know if she's here, but she was also a big help here. There's a reception that's going to be in the lobby.
Too hot.
Not too hot.